Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And here we go. Here we go. Tonight is just for you all and me, you all and me. We are going to Twitter Law School. Ladies and gentlemen, I hope you are ready to learn from the preeminent minds, the big brains, the smartest, the best, the brightest the internet has to offer. Comic book professionals, ideologically aligned to Mark Waid, giving legal advice all over, with all of the authority, with, oh man, guys, the knowledge that they are dropping, I can't even describe it. I can't get to it. It's, okay, so I have a confession. I started to do some show prep. All right? I started to do some show prep. I've got clips of all these different tweets. No, this stream is not sponsored by Under Armour. I've got clips and screenshots of all these different tweets, and I'm like, yeah, this will be good. And then I noticed that it's impossible. It's impossible to clip the level of wisdom because I don't have time and I don't have enough interns. So instead, hold on. We're just gonna go through and start picking gems out. We don't even need it. We don't even need the clips. We're gonna do it live. And I hope you guys brought enough liquor and happiness to get you through some of this, because it's gonna be painful. There is no sponsor to this program other than you fine folks in the chat and my wonderful supporters on Patreon. You can check it out. Oh my goodness. I didn't change the caption. Let's do that real quick. You're going to see some top level getting... Oh, wait. Hold on. Let me caps lock it. Getting that Twitter law degree from the sickest pros. There we go. Sorry. Very unprofessional of me. How dare I act in such a low and unprofessional manner? I should be less biased and more dignified in how I do these things. I can't get a camera angle that I like tonight. All right. And I'm sorry that this is a little indulgent. If I were on American Idol with Simon Cowell, he would tell me this is a bit indulgent. But again, it's when people come into your house, it's not my house, right? I'm just renting. But when people come into your area and they start telling you what you're doing is wrong, you take offense to it, right? Comics pros? Isn't that what started all this? Some no-name rando on the internet started criticizing your precious little projects, and you were like, wait a minute now. How dare you? How dare you, sir? Don't you mess with my drawings and my art and my writing. You can't do this. You've never written a comic. You don't know how hard it is. Right? Isn't that what happened? Yes, of course that's what happened. And that has led to this. Reality has caught up to the Twitterverse, and now you all get to pay for it. And I can't stop laughing at how you thought that nothing mattered. You thought everything was pretend. You thought you could ruin people's lives and careers and passions for pretend. It's not pretend. Make a better product than them, because that's how competition works. Squealing to mom doesn't work, because when you squeal to mom and she has a contract with your competitor, that's illegal. All right. I'm going to drink a sip of tea, and then I'm going to pour myself a glass of whiskey. And here's how we're going to do this. All right. I've got 2 super chats to start off the night. The first one, I owe an apology to True American Hero, who I called an idiot. And I believe, I don't quite remember when, but I'm pretty sure it was on the heel stream. I called him an idiot. And for that, True American Hero, I do apologize. Again, we've discussed who you are, and you know I love you, buddy. You know I do. And the idiot was said with all love and affection that could be given. So I apologize. It was not meant for offense. All in good fun and good faith. Bagel Goose says, for the Twitter drinking fund, thank you, sir. Larry Bernard says, more scotch for the Scotch God. Thank you, sir. All right. So tonight, what do we start with? We're going to go Japanese in honor of this not being an anime. Whoa. Uncool. Look at this, guys. That's when your cork breaks in the bottle. So we're going to go with a different Japanese until I get a cork extractor to get that thing out of here. Oh, Twitter dunking fund, not drinking fund. Holy cats, guys, I haven't even started and I can't read. Oh my. All right. So here's how this is going to work. Here's how this stream is going to work. I'm going to go through. I'm going to start. We're going to pick a rabbit trail and run down it until the jokes run dry, and we'll pick another one. If you have a specific tweet that you want me to see and look at and make fun of, please, limited to legal issues if you could, just because, I can't find them all. I was digging through Jamal's tweets, and I found the comic lady lawyer, who's apparently a lawyer in DC who talks about comics. And I mean, her opinions are baffling. They're baffling. I don't understand how I don't know what area of law she practices. I'm not saying she's not a lawyer. That happens to me all the time. I'm allegedly or supposedly a lawyer all the time. Whenever someone's losing an argument, that's going to come out. Go look it up, guys. You can find me really easily. I'm very much a real one. But anyway, so I'm not gonna say this person's not a lawyer, but their analysis, a bit lacking, I'll say. And we'll talk about some of those. So I found a whole plethora of tweets I didn't even know existed. I've been on Twitter for like 20 straight hours, and I didn't even know that there were like hundreds more of these things. So if you've got something, throw it in a super chat, and I will specifically pick out that tweet, and we'll run with it. Otherwise, and you do not have to do a super chat to get comedy out of this show. I'm going to be just going through these things like crazy, and we're just going to go there's going to be jokes and also legal analysis and corrections, and we'll give them props when they're right. Okay. So this is a semi-legitimate thing. But yeah, if you have something specific, throw it in the super chat and I'll definitely look at it. Otherwise, enjoy. Welcome. If you're new here, welcome. Please subscribe. We're on the path to 10,000 subscribers, which this all started as a joke to make fun of Maddox in one small series of videos. It was supposed to be like 3-4 videos, and now it has blown up into something that is so much fun for me, and I appreciate it very much. So if you like this stuff, share it. Help me get to 10,000 subscribers, and we'll see what happens. All right. Whiskey begins. Couple more super chats. Keck7Go. How does it feel to be the same opinion of Leonard French on this lawsuit? To quote a great man, death is nothing to vindication. I have not watched whatchamacallit, Leonard French's video on this. I've seen it linked alongside mine, so I assumed it was of a similar vein. I'll have to check it out. French is a good guy, of course, but I haven't seen his opinions. But if they're the same as mine, then he must be on the right track. Trevor says chuckles in lawyer. There's going to be a lot of that. And again, guys, this is definitely, this is Smugtown. Smugtown. The other video was smug. This one's going to stay smug. And I hope that's okay with you, because I can't undo it on this topic. You'll find me somber and professional on plenty of topics. This is a topic for mirth and joy. All right. All right, guys. Let's see. Will you cry like Mundane Matt if you ever hit 100,000 subs? I'll cry so much harder than Mundane Matt. I'm going to put that fat fatso to shame. I'll cry so hard. I'll be finding boulders in the streets. This will probably get you run off of Twitter. Okay. Whatever. All right, guys. Loose for Love Monkey says, this should be good. Practice my straight face. Okay, never mind. Okay. All right, let's start going through these. You know, I apologize in advance for all of Jamal Eigel's silly opinions on Trump and Kavanaugh as well. And I don't even know if they're right or wrong, but I do know they're silly. So we'll ignore that. We're just going to go with we're just going to stick with the issue at hand, which is diversity in comics. All right. I see the word attorney and I know to pull this up. So, okay. All right. Colleen Duran, YouTuber who called women professionals C #M dumpsters and slapped others with pedophile slurs, suing Marvel DC writer for defamation. All right. So let me lay something out here. Tu quoque is an interesting fallacy, right? It's a logical fallacy. Tu quoque means you also, or them also, or you the same. I don't know the direct Latin translation. If you do, great. But it basically means this other person is doing it. That's not to quote Stefan Molyneux, not an argument. Not an argument. All right? It's not, it doesn't count here. Tu quoque is not a valid excuse to defamation. So even if Meyer was libeling or slandering or whatever they want to say with the wrong term, otherwise defaming people, that doesn't give anybody else the right to defame him. So let's immediately annihilate the tu quoque approach to the Meyer lawsuit. If they have a cause of action against Meyer, even though those people are not party to this lawsuit, you can't rescue someone with defamation, Mark Waid. You can't white knight with defamation, Mark Waid. So if he did those things, and I know the context, he did it in a dark roast. It's labeled a roast, a dark roast. He's labeling it as a comedy opinion, not to be taken seriously. One of the elements of defamation is, would a reasonable person observing this take it as a statement of fact? Now, do they think it's that these women professionals are literally dumpsters full of semen? Because if not, you're already on the rocky path away from defamation, okay? So, but tu quoque doesn't work. All right, so let's get into the opinions, though. Violent pacifist. Didn't he directly insult and slander Waid as a pedophile? No, to answer you, he didn't directly insult and slander Waid as a pedophile. if I remember the exact words from the dark roast, of which I'm actually not aware of much of it. Only about like 2-3 minutes, I think I saw on Twitter the other day. He said, these guys all look like pedophiles. Look like pedophiles is an opinion about appearance. What are you going to do? Go to court and say, I don't actually look like a pedophile. That's a lie? Well, how do you know? Pedophiles look like all sorts of different things. Is a pedophile, is preying on children, is trafficking children, touching children, having sex with children. Those are statements of fact. Looks like a pedo is a statement of opinion about how you present yourself, how you appear, and how you strike the person. Not actionable. He didn't actually say you were a pedo. He didn't. Not at all. Okay, anyway, I hope he doubles down and countersues after Meyer's case is thrown to the wind. Yes! Please do, Mark Waid. Please countersue your boy Zach. Let me drop some inside knowledge on you guys. Do you know who Zach hired? It's a guy named Daniel Byrne. Now, I'm not going to sit here and happy fillet some other attorney. I don't know much about Byrne other than his corpus vitae on his own website. All right. And that he's a super lawyer in the Texas Super Lawyer, which is just an ad. Being a super lawyer, Mark Zaid, is an ad. Actually, there are law articles out there, law review articles, questioning the ethical ability of lawyers to call themselves super lawyers. Because it's a form of advertisement that doesn't really mean much of anything. And it's very vague to the general public. But anyway, I'm tangenting. His lawyer specializes in anti-slap litigation. We didn't talk about that on the other stream, but SLAP is strategic lawsuits against public participation. So please, Mark Waid, from one lawyer to you, please countersue Diversity in Comics for defamation. Please do it. Please sue someone whose job it is to be a critic on YouTube for defamation of character based on his saying that you look like a pedophile. I think you'll do well. I don't think the anti-slap suit that follows will be devastating at all. Okay, so yep, and it's been captured and shared with his attorney. Whew, good job. You get him, guys. All right, here's the next. I imagine if this reaches Discovery, they'll also be able to dig up Richard's old and deleted tweets, videos, etc. as well. This is gonna be fun. Yes, digging up his public statements, that's where Discovery really shines. Lucifer Love Monkey, of course it's not legal advice to Mark Waid. I don't have a lawyer-client relationship to Mark Waid. I'm just hoping he takes that to his attorney and discusses his prospects and decides to act in that way. That's friend advice from me to you. All right. So again, unearthing Zach's public tweets and videos and all of that. Great. What do you think that's going to do? None of this is a defense to Mark Waid's defamatory statements or his tortious interference. And that's what these guys don't seem to have figured out. Now, of course, Mark Waid can assert truth as a defense in his defamation act. He can do that. Here's the problem. He can assert falsehood and then force Diversity in Comics to show that these are true statements that they made, truthfulness as a defense. Okay. Or wait, I got mixed up. Sorry. Diversity in Comics is suing Waid. My brain's going back and forth. All right, so Diversity in Comics sues Waid. Waid says, for defamation. Waid says, no, these are true. Now Waid has to prove they're true. All right? The Discovery isn't going to bring up the truthfulness of the claimed defamation, which, if you'll remember, is something along the lines of he's a racist, He's a serial harasser, and he's associated with white nationalists, or affiliated with white nationalists. Those are the 3 defamatory claims in the document. So unless you find proof that he's a racist, which is an opinion probably not actionable anyway, but serial harasser, you're going to have to, that's a claim that might require you to fulfill some of the bullet points on harassment. And if you can't do that, it's going to be a tough one. All right. So this is a short thread. This is the warm-up. Let's get to the better ones. And just so you know, Jamal Igle knows what the Devil's Triangle is. He's old enough. I'm not supposed to focus on that. Here we go. Here we get some of the credentials. So here's the original tweet. This is where a lot of our source material is going to come from. And we're going to... Let's start here. Hashtag, I stand with Mark Waid, obviously. Beside him usually being on the side of the angels, this suit will fall apart the moment a judge asks what prevented you from pursuing a publishing deal with another company. Let me help you out, Jamal. No. The verdict on this legal opinion is no. You idiot. No, it doesn't matter if you can get a publishing deal with another company. If you interfere with an existing contract, that's the tortious interference. That's what matters. It doesn't matter if there's 1,000 contracts waiting on the other side. Just like if you call and illegally get someone fired when it's not your business to do so, you have no legally protected interest to call and get someone fired. Like you're just like, you know what? I'm going to call up this person and this person's employer and try and get them fired. That's tortious interference, okay? You have to have a legally protected interest in making the claims you're about to make to get them fired. If you don't have them, it doesn't matter if they can get 100,000 jobs the next day. You've messed with their existing contract. That's an element of tortious interference, Jamal. I know you took a business law class and you worked like in the mailroom at some firm somewhere, but you missed this lesson, apparently. I don't know. And yes, they would have just chased him to the other company. Alan Grant, thank you so much, buddy. So, yeah, it's going to fall apart. No, it's not going to fall apart from this. It certainly could fall apart. There's all sorts of scenarios in which a lawsuit fails. All sorts of scenarios in which any lawsuit fails, even if the claims look well-founded from the onset and they're made in good faith. Which I think, based on what I've seen, I think these claims are made in good faith, and I think they're well-founded. Sufficient legal basis. I have a suspicion that there's more details that we still don't have that make this an even better case. There are lots of reasons for that, and we'll talk about those as the night goes on. But I have a suspicion that there's more to come that makes this an even better case. And I bet Waid is talking with his lawyer about those things right now, as he figures out how to respond to this, okay? But anyway, yes, this is not an accurate assessment of tortious interference. So this is not where it will fall. Not a chance. Because this isn't an element of tortious interference, nor is it an affirmative defense, nor is it a common law defense. It's just nonsense. It's just a statement made by a dummy online, and it has no bearing on any of this. Okay. Good Kevin meme. Jordan Plosky. Seriously, this guy is virtually unemployable. I mean, I think Meyer is gainfully employed. Last I checked, maybe he's not. Maybe he resigned due to the success of his comic. I don't know. But last I checked, he was employed. That was back in May. Alex Nieves says, Nick Rekieta, Ordo Hereticus Esquire. Good work, champ. Thanks, buddy. And, well, it's up there. Hereticus is up there. So this guy's virtually unemployable. An employer has every right to terminate a contract for any reason. No, they don't. For example, Jordan, you're talking to Jamal. If Marvel called Jamal up and said, or wait, he doesn't have Marvel, whatever. Whoever holds Jamal's contract called him up and said, we're firing you for being black. Nope, can't do that. Can't fire someone for any reason, can you? And if you have a contract that lays out the terms of your employment, then you better fire them within the contract. Even if you're in an at-will state, you moron. Because you have a contract, which is a set of legal promises that you make with obligations attached to those promises. You create duties. When you have breaches of that duty, you're done. You're done. That's a breach of contract and you get sued. But Anarctic Press wasn't hiring Zach. They weren't hiring diversity in comics. They're making a business arrangement, whereas he would create a book, they would print and distribute the book, and they would split profits. It's not an employment contract, so even if your statement was correct, which it obviously is not, it would be irrelevant because it's not an employment agreement. Especially a 1099. No, still governed by contract. You can't fire an independent contractor for various things if it's a violation of their civil rights. How do you guys not know this? You're on the side of social justice. You should have studied specifically civil rights law. You have to know what you're saying is wrong. That's your whole wheelhouse, which a freelancer generally is. As for Waid, giving an industry colleague advice on a hire is not a legal matter. First of all, it is a legal matter if that advice is to interfere with an existing contract that you know about, and then you do. I've been saying this to people all flipping day. Guys, like, I think Lady Rackets is mad at me. Not really, but I was on Twitter all day because it was exploding with the same stupid arguments. What do you mean you can't just call up someone and ruin their business arrangement? What are you talking about? Of course you can. Of course you can. If you can't do that, we're all in trouble of being sued at any moment for our one pastime. Our one masturbatory act of justice is potentially actionable in court. So you have to be wrong, because if you're right, I could be sued. I've been dealing with this all day. All day. It is illegal. It is unlawful. It is against the law. Guys, I looked up the history of tortious interference. The first case was in 1620. This isn't new. I mean, I said it before. I thought it was like maybe 100, 150 years old as we started to get really into corporate protectionism and stuff like that. No. It's 400 years old, this common law principle of tortious interference. All right. Waid gains nothing. Waid gains a lot. Waid puts so much value in virtue signaling, and it's blindingly apparent. So, of course, why do you think he went on a tirade across all of social media about how he was going to ride in and save Anarctic Press's fragile reputation from your boy Zach? Why would he do that if he gains nothing? Of course he gains something. That's his whole thing. It's part of his brand management to be an insufferable cuck on social media. That's how he does it. Mithrin Emrys. Sorry, Nick, I have to disagree. Those who worship at the altar of social justice seem to have the least grasp of actual justice in the law. I see it in my classmates every day in con law. Mithrin, buddy. Nomini et Patri et Filii et Spiritus Sancti. You poor soul. Con law is the worst. It's the worst because of exactly what you're saying. Yes, I agree. They don't seem to have a proper grasp on actual justice, but they should. They should have a principled approach to what civil rights was, because they should know that you can't just discriminate against people. And then you can extrapolate beyond the law and say, in principle, we just shouldn't do it. Even if it's not laid out in the law, we probably shouldn't discriminate. And then, there's a difference between legal liability and then, of course, what our personal choices are. But they should know. But yes, I'll concede. I'll concede to that argument. Thank you. Best contrarian argument I've gotten today by a mile. Rockep Ship. I'll have you know, sir, my uncle's friend was a lawyer, making me a super mega internet lawyer. We're going to find that tweet from Jamal too. Chuck Harden says, do these people ever ask themselves how they feel if this happened to them? What laws they'd want to use to defend themselves? I mean, I think they do. I think they have to consider it, but it's always an abstraction. It's an abstraction because they're never wrong. That's how it's got to be. They're never wrong. And remember, they don't know that what they're doing is illegal. They have no concept of it, and they don't want to. It's blissful to remain ignorant. So, I think that's where they're stuck. They don't want to learn it. So then it's always an abstraction. It's always someone else. It's never their own actions. Bradley Parker, we'll get to that Waid's lawyer's response. Because we'll talk about that. Thank you again, Alan Grant. There's a question. I see it. I heard on Twitter that Zaid might defend this case on a free speech basis. Would this be possible? And if so, how would it be done? Sort of. The free speech argument is that there is some, let me be very clear. There are not cases that resemble this one readily available through the amount of research I've done on tortious interference in Texas, which is outside of my jurisdiction, but I have done research trying to find the most comparable cases that I can. It's very hard to find social justice warrior calls up someone righteously indignant and gets their contract ended. This is it's honestly a very novel thing to have people actually suffering from this. It's very 2018. There's not a lot of case law around it. So one of the defenses to tortious interference is if the statements that you're making are truthful statements. If they're truthful statements. However, big caveat, that's typically in the context of you having a legal responsibility, duty, or right to make those statements. So, calling up and giving someone an opinion about someone, giving a third party an opinion about someone else in an attempt to get the contract broken, an opinion might not be a sufficient truthful statement. That's an opinion. It's not a statement of fact that is truthful. But I have to point out, most of the cases where we draw this sort of conclusion are cases involving employment disputes, like direct employee disputes, and another company calls for a reference. Importantly, the hiring company calls for a reference from the former employer, which they have a legal right to do that, to make an inquiry, and then the former employer responds with truthful statements. That is a massive difference from a non-former employer, random person who doesn't like the plaintiff calling up for no legal reason to give statements. So Waid is going to try and use this as a truthful defense. In all honesty, it is somewhat of a valid defense. I don't think it's a great defense by any means. And I think his statements are exaggerations. I think they're hyperbolic, and I don't think they would qualify under what the court has routinely found to be truthful. And it's very distinguishable from those cases because there's no prior relationship between Waid and Meyer or Waid and Antarctic Press. Were Waid being published by Antarctic Press, that would change this landscape dramatically. He's not. He's not. So that's how they're going to try the free speech approach. I'm probably going to do a separate video talking about the defenses Waid is likely to make, although I think we're going to find out in about 11 days anyway. So we'll see. We'll see. But that's a great question. Great question. Okay, next. Chris Banks says, bad things to meanies and good things to me shall be the whole of the law. Apparently, cognitive dissonance is staggering. Yes, it is. Mithrin Emrys says, just so you understand my pain, this week has been Dred Scott, Slaughterhouse, Bradwell, and Crookshank. The spurge outs are massive and painful. Oh, man. Mithrin, my friend and frequent companion on this live stream, who I very much appreciate, or these live streams, very much appreciate. That's for you, pal. That is for you, pal. All right. Next. Here we go. Let's see if Jamal's got his legal analysis on point yet. It also requires him to prove that the deal was canceled because of Mark. Nope. No, it doesn't. I love it. I love it. Which they've denied multiple times publicly. And as of late, Neater has taken to trolling Antarctic on social media. I don't know who Neater is. Who's Neater? Can someone help me out? Yeah, according to Mike, yes, thank you. I've done reference checks. We're limited to what kind of questions we're allowed to ask. Yes, because of this question. Companies get sued for this stuff constantly. Counselor, are these people just obtuse or daft? Both and. Slash Halen, no luck talking to Movie Bob. Okay. Let me pull up, if you'll humor me here. Give me 1 second. Oh wait, that's the wrong thing anyway. All right. Let me pull up a case. Very important case. I've talked about this on Twitter. We're not going to dive super deep into this case because that's a different type of video. That'll be kind of boring. Let me, all right. Let me see. I have to see if this is coming through. All right. So here's Knox v. Taylor. All right. And like I said, we're not going to dig super deep into this case, but I want to point out something in Knox v. Taylor. This is big. Not big, but this is relevant, extremely relevant. This is one of the closest cases I have found in this sort of thing, but it's a big case with a lot of moving parts, a lot of libel and slander that's related directly to the tortious interference. If you notice, Mark Waid does not, or your boy Zach does not assert that Mark Waid libeled and slandered him directly to Antarctic Press. He addresses his statements generally. And I'm not entirely sure what the strategy is there, but his lawyer's good at this, so I'm not gonna delve too deep into that. I assume he has a reason. I don't know what it is. I'm not gonna like shill for him and say that it's the best move ever. I don't actually know. Chuck Harden says, I wonder how these people would feel if you went to their studio and told them how to draw. I should start doing it because I draw. I'm terrible. I'm a terrible artist. So whatever. All right. Let's get to the important parts. We've got tortious interference with a contract. Oh, that's going to be up here. Hold on. Wow. All right, we'll just scroll through. I'll find the tortious interference claim. Let's get the background down. Okay, so Mithrin says we need to debate Westlaw versus Lexus. Here's the debate. I have a contract with Westlaw that doesn't expire for like 2 more years. So I choose Westlaw every time. Okay, so here's the basic background of this. I've got it up here in case you want to snip this background and read it later. It's not super interesting. There are 2 companies. One is like a guarantee or a managing agency, and the other hires them. And so then this guy, this third party, sends out a package to this company's CEO, the hiring company's CEO. They've hired this management company, okay? So he sent a package to the hiring company's CEO with a memo and 2 lawsuits that he filed against this management agency, all right? And the intent, the court ruled, was to get their contract dissolved, okay? That's the basic basis here. The libel and slander is a different, I mean, it's part of this all, but it's not super important here. What we need is the tortious interference, and I'm gonna talk about why. Here we go. Let's hit some main points, all right? This is an important point. Generally, merely inducing a contract obligor to do what it has a right to do is not actionable interference. Okay, that's fine. So if they have a right to break the contract and inducing them to do that, generally is not actionable interference. Although it can be. Not really important here. We don't have any physical contract with between Zach and AP. I'm assuming it's either a contract by email or an oral contract. We don't really know, but the terms are not laid out. So I'm guessing they don't have like a morality clause and all of that, because that would be in the further memorialized agreement, which I don't think exists. All right. So but here, importantly, in this case, the contract was terminable at will by either parties. Remember earlier they said you could fire someone for any reason? This is like that. It's terminable at will by either party. Now, someone called these guys and said you should terminate or not called them, but sent them a memo that was intended to get them to terminate their at-will contract. And they did. Now, in doing so, they did induce a breach because they did it too fast. So there's a little distinction there. But they did have the right to terminate this contract at will. And even though they could do that, they hadn't terminated it prior to the interference. Brings it into tortious interference. These are important points. So therefore, it is no defense to an action for tortious interference that a contract is terminable at will. Because guys, even if they could terminate it at will, nothing says they were going to. That's the whole point. All right, next. Watson. Watson is the CEO who received the package from Knox. Okay? So to analogize this, Watson is the CEO of Antarctic Press in our hypothetical or in our analogy. Okay? Watson's the CEO of Antarctic Press. Knox is Mark Waid. Taylor is your boy Zach. We good? Knox sends a package to Watson. Waid calls AP. Same thing, all right? Now, Watson, who is AP, stated the memo had no effect on his relationship with or opinions of Taylor. AP has said that Mark Waid's call is not the reason. Now, there's all sorts of qualifications for what they said, because it was like the social media guy, not the actual head of AP. Either way, doesn't matter. Right here, Knox versus Taylor. Watson stated the memo had no effect on his relationships with or opinions of Taylor. Read it this way. AP stated the call had no effect on his relationship with or opinions of Meyer. If you read it that way, It's the same thing. The court still ruled in favor of Taylor. Because guess what, guys? When you breach a contract, you're not generally on the side of the person you just screwed. AP is not on Meyer's side here. They might be on Waid's side, but at best they're neutral. So when the court listens to them and says, okay, I don't care why you say you did this, the question is, what does it look like happened? Because it sure looks like this person contacted you, you had a contract that was going just fine, and then after they contacted you, you decided to breach. Boom, tortious interference. That's it. No matter what AP said, it doesn't matter. Doesn't matter, Jamal. It doesn't matter. This is Texas law. It's been there since 1999. It's still good. It doesn't matter. All right. But look at this. Let's read this next paragraph because this sounds so much like this case. Taylor testified that he told Watson he would form an MGA only if Titan agreed to 10 to 15 years arrangement. Here we go. This is where I want to get to. Watson stated he did not have any problems with Taylor's operation in 1993. Does that sound like AP's tweet prior to Waid's call that says, yeah, we're publishing Jawbreakers with Richard Meyer. We're doing that. We're going to do that. In fact, Watson believed Taylor helped Titan in controlling losses, blah, 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 blah. Finally, with respect to whether receiving an anonymous package accelerated Titan's decision to exit the contract surety business, Watson responded, I'd say it was, sort of icing on the cake. They had already decided to end their contract. Doesn't matter. Court doesn't care about that. But here's the other thing. Here. Appellants asserted that prior to November 93, Titan had twice notified Taylor of its desire to end its contractual relationship with SMGA. The first notice was in July when Titan sent Taylor a provisional notice of cancellation. Taylor testified that he talked to Titan about the notice and asked that it be withdrawn. On August 19th, Titan agreed to withdraw the notice and stated it was pleased to continue working with Taylor for another year. The second notice, according to appellants, when Titan wrote Taylor seeking different bond writing, blah, 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 blah. Here, Taylor wrote Titan stating, each time we meet, I feel better that our business relationship will be long-term and profitable for both of our companies. Does that sound like AP saying, yes, all of the comic shop owners colluding against Zach, right? AP says, this is how I know we're doing the right thing in publishing Jawbreakers. This case is so close to this without being able to be identical that it's stupid. It's stupid. So Taylor made this statement. So only after they got the package or received the phone call in our analogy did breach occur. Knox versus Taylor. You're welcome, Zach. You're welcome, David Byrne, Daniel Byrne, Daniel, whatever your name is, David, I think. You're welcome. I know you've already seen this because you do this for a living and this is in your jurisdiction, but if you hadn't, you're freaking welcome. Knox versus Taylor's such a close analog that it's stupid. It's stupid. And of course, if you tell these dummies anything about it, they're like, whoa, that's not a comic professional making a phone call to a publisher. What do you want? What do you want from precedent, you idiots? All right. Sorry. The Vile Delinquent says, sorry for being late. Watching you LTFO that dude on Twitter was hilarious. Here's $5. Are you now on retainer for me? Thanks, buddy. No. The retainer's much higher. Lucifer Love Monkey says, what happened to that Waid interview? Didn't Waid say he changed their minds? Yeah, it's in Bleeding Cool. It's still up. Go read it again. Or if it's gone, it's not. But if it does manage to disappear into the memory hole, watch my video. I read his statement straight through. My initial video about this back in May. Go watch that if you can't find it. Go watch it anyway if you want some laughs and you haven't seen it. But I mean, Waid can't help. He can't help burying himself. He's just grabbing that shovel and just scooping the dirt in. Yeah, like imagine Waid standing in a grave with flash dance chair and bucket, and he pulls the chain and just a bunch of dirt buries him. That's Waid and his public statements and his virtue signaling. Splendopia says, "You earned this, brother. I want to hear you every day until this case is decided." Well, subscribe, because you're going to hear a lot of me. It won't always be on this case, but anytime there's something new to talk about, we'll be covering it. Absolutely. Absolutely. Cave says, so in essence, AP denying the call influenced them, confirmed the call to influence them took place, eliminating a line of defense. Yeah, and no one's under any illusions that this call took place. Waid bragged all about it. He did a full interview with Bleeding Cool and told them all about his conversation, in which he makes all sorts of stupid admissions. All right, this is Knox versus Taylor. Get out. Get out. Boring law stuff. But, so, let's get back to where we are, which they've denied multiple times publicly. Doesn't matter, Jamal. Doesn't matter. Existing precedent in Texas says the statements of the breaching party about why they breached a contract after it sure looks like someone interfered with it, we're not going to pay too much attention to them saying that. There's all sorts of reasons they might. And guys, if AP was scared of Waid when he was about to publish Zach, think about how scared of Waid he would be if after breaching he said it was Mark Waid's fault. All of the reasons to lie about it still exist. They still exist. So of course he says it wasn't Mark Waid. But did he ever say it was? I'm betting we gotta find out. And remember that if this gets past a settlement, it goes to depositions. And that's where AP's CEO is going to be under oath talking to Zach's lawyer for a very long time in a pretty warm room. And he's going to have hard questions. And if he lies, it's under oath. So we'll see then, won't we? We'll see then what was the cause of that contract breach, right? Larry Bernard says, breaching is like lying. Do you trust a liar? Exactly. In a lot of ways. It's not directly analogous, but it's close. All right, so Jordan Plosky. Moving on. Further proving the point that he is a bad hire. He didn't hire him. That whatever was said, if anything, Zach was hiring Antarctic Press, by the way. He's the creator, hiring a company to print and distribute. If I went to a printer to print off a stack of cease and desist letters, I'm hiring the printing company. They're not hiring me. So that's weird. That whatever was said in order to protect Antarctic was provably accurate by his behavior towards them as a result. No, that's an ex post facto argument? I hate to break out the logic terms, but I'm sure the big brain pros can help me out with them. Crazy that he thinks he has a case. Yeah, just nuts. Just nuts that there's a huge body of law about tortious interference and he thinks that his falls directly into it, which it obviously does. He'll wind up getting countersued and lose bigly. Do it. Do it. Do it, you dummy. Do it. Mithrin Immis says, Knox will be persuasive if it ends up in the 1st district, a slam dunk if it's in the 14th. Houston is weird that there are 2 appellate districts, plays heck on the lower courts. They have 2 sets of precedent and try and follow. That's a deeper dive than I'm going into on precedent and jurisdiction, Mithrin, but thank you for the input. Fantastic. This is why I love law students, because they're better at this than a lot of us. Okay, here's my next favorite statement. Sorry. I should have warned you, trigger warning, before pulling up a picture of Mark Zaid. Some people might have been shocked that a picture of that man would show up. But there it is. So back to the Eigel of Dr. Moreau, attorney at Twitter. Meyer and his attorneys clearly didn't think this suit through. Mind you, They're running this as a parallel argument to, why did it take him so long to sue? Oh, yeah, you're right. You know you're right. Here's what happens when a client walks in my office, okay? They walk in and say, you know what? I got this problem. I think maybe this guy screwed me over because I've been talking to some people and they say, maybe I've got a case. And I say, okay, sit down. Let's start talking. And then they tell me their thing and I say, let's sue them. I don't know if you have a case. I don't know anything about your claim. Let's just draft a lawsuit and not think this through. It's only a violation of my ethical obligation to you. It could get me disbarred. It could get me sued for malpractice. It could only do all of that. But you're right. You're right. His 35-year senior partner at a law firm attorney, that guy didn't think it through. Jamal, you idiot. You idiot. What do you think this is? You think this is Twitter? A tweet costs you nothing because everybody knows you're a giant moron. But it could cost this guy his career, you stupid man. Next, this is Waid's lawyer. By the way, one of his specialties is tort law. Guys, you want a lawyer who specializes in tort law? Look at every billboard on your commute to work. Every one. Hit by a drunk driver? Tort law. And I am not disparaging those guys, by the way. They make a fortune. They make way more than I do because people die and then they get compensation for the families left behind. That's tort law, though. Every ambulance chaser. So when you see all the ambulance chaser slurs come out in their stupid tweets, all the ambulance chasers specialize in tort law. Because that's personal freaking injury, Jamal. You worked at a law firm. Mithra Nemers says, but Matlock gets it done in an hour. And no disparaging to Mark Zaid. He looks like look at him. Looks like a very competent attorney, right? He looks like seriously, he's got an impressive bio. He's done great work in other areas. Absolutely looks like a competent attorney. But specializing in tort law, guess what? One of Meyer's lawyers, one of his specialties is tort law. Dumb. The VOD Delinquent says, Nick, come on, are you saying Twitter is not the same as a courtroom? Ridiculous! All right, so, okay, Mark Zaid joke, some Mark Zaid jokes. Okay, so that's the end of that portion of the thread, and we're going to move on to the next reply. Here we go. I don't know. I think this guy, is supporting Jamal with this. Quote, Your Honor, I'd like to submit that my client is a talentless, entitled, jealous, egotistical butt bag of a bigot that no one with a shred of decency could tolerate in a personal manner, let alone a professional one. Hey, you know what? You know what's great about that? That might actually be part of his opening statement in some way. When he says, get out ahead of the argument, you idiot. You get out ahead of the argument. So when he gets up there and he says, you know what? My client's made a few mistakes in his life and he's made some enemies. He built his YouTube career and fandom and online presence by mocking and deriding the works of other people. And sometimes that mockery was a little bit mean. But it was always his opinion, and it was always genuinely an opinion. Uh-oh! You just told the judge that your client is sometimes mean to people. Now what happens when the dummy gets up and says, that guy's mean? Yeah, I know. He admits to being mean. He's actually said that he did this dark roast that was probably not really his thing. Yeah, he might actually get up an argument. Exhibit A, look at that dude. Seriously. Solid legal advice, buddy. Great Loner says, enjoy a free shot. Thank you. Thank you. Finish that up. It's time to pour number 2. All right. Next thread. I think there were 18 threads off of this one that we got to follow through, some of them at least. He's actually suing. Yes. Okay, so that's not important. This is boring. Oh, here we go. Here we go. This is good because I'm pretty sure that this is a slight at me without naming me. All right? So these are fun. These are fun. I'm interested in seeing how well, quote, legal suggestions via YouTube commentary is going to work out for him. I don't know. Maybe it's not the YouTube commentator that he listened to, considering I did a video in May and your boy filed in September. I bet maybe he talked to some other people and found out that I wasn't wrong. and I've never said he'll definitely win this case. To be perfectly clear, I think he has a claim. I think it's pretty good. I think it's getting better by the day. But I've never said he'll win. For sure, he might. He might actually win. He might not. But what's interesting is that he found someone who's reputable, who at least agrees enough to take it and put their name on it and not worry about it being frivolous to the point of them getting sanctions against them. So we'll see. We'll see. All right. Here comes a guy trying to help him out. No, I don't want that. Hold on, let me get back to it. I just clicked on something on accident. Okay, so Joey Essex tries to help. In your opinion, what are the odds? The odds are this never sees a courtroom. The odds are this gets settled out. And here's why. Waid's lawyer has heard Waid's side of the story. Now Waid's lawyer has gotten the complaint. All right? And they've had a discussion. And I know Waid's lawyer made a big statement to Bounding into Comics, I think it was, or Bleeding Cool, whichever one he was quoted in. He's like, "Yeah, we're gonna defend this. I'm big comics guy, and we're gonna defend it." You wait till all of the evidence, all the screen caps of everything Waid has said, the responses from AP, the emails Zach had with AP. Watch. We won't get to, but here's what's gonna happen. That lawyer is going to keep getting emails and things like that from Zach's attorney, not from you guys, not from me, from Zach's attorney. And he's going to go, there are 4 elements to tortious interference. There are a couple defenses that we could try. And each one of those boxes is going to get ticked by a piece of the evidence. And some of them are going to get ticked 2, 3, 4, 5 times. And each time that happens, he's going to say, hey, Mark, let's talk about this. Let's talk about what you want to do with this lawsuit, friend. Because Mark Zaid looks like the kind of attorney who's an ethical attorney, and he's going to be having these conversations quite a bit. So that's the odds. That's the odds. All right. So Joey Essex, yeah. Jamal, you're not a lawyer and you're embarrassing yourself. Besides him being on the side of the Angels, OMFG, yeah, that should do it. Pursuing another publisher has no bearing on this. You really are a joke. Focus on your failing career, buddy. Solid legal and professional advice. Failing career? You mean the successful launch of Baltimore Comics, Ahoy Comics Mags, The Wrong Earth, called one of the most successful new launches of 2018? Does anybody, free option in the chat, can anybody fact check the success of The Wrong Earth? I have no idea any of this stuff, because if there's one thing I'm not buying, it's Jamal Igle comics. And that's not a personal choice. I just have no idea where to buy them or anything like that. And no interest in it. No interest in it. It's not, it's nothing against Jamal. But, I have no idea what those things are, what they're referring to. Next. Okay. Oh, here's The Wrong Earth. Jamal Igle on there. Ahoy Comics. With W. Tom Payer, Paul Constant, Keck W, Juan Castro, Carol Lay, Tom Feister, Jamal Igle. Okay. Extra feature. Dragonfly Man and Stinger confront the dastardly menace called NIMBY, plus a text story by Keck W, illustrated by Carol Lay. This stream brought to you in part by unsolicited advertisements for Jamal Igle's book. Wait a minute. The Wrong Earth, called one of the most successful new launches of 2018, in shops October 10th. It hadn't even launched. Oh my goodness. All right, Cornelius Minor. We can also talk about Mr. Minor's new book from Heinemann Pub, which I drew the cover and interior illustrations for, now available for pre-order. Okay. I stand with Jamal Igle. He's got you, boy. Good. You should stand by your friends. You should do it. Part of standing by your friends is letting them know when they should maybe chill out. You don't do that publicly, of course. Send them a message, be like, hey, buddy. Send him this picture. You liked Wrong Earth? You can like it. It's fine. It's fine to like Jamal's product. It might be good. I don't know. I have no idea. Again, I don't buy his stuff not because of some principled stance against him. I buy products of people I disagree with and think are stupid all the time. It doesn't matter. Is a product good? It's a product good. Andrew Daly says, hey, Nick, I just want to say I love your work. Also, I am a 2L. Do you have any advice to avoid burning out and staying focused on my studies? Thanks. Buddy, make good friends. Make good friends with a couple of your classmates. They're the only people who know what you're going through. Don't watch Law and Order. Don't watch a bunch of legal shows. Turn them off. So, that's the best advice. And stick with it. You're almost done. And by almost done, I mean you're just starting your second year. But it gets better. It does get better. Hashtag it gets better. It gets better, buddy. No, it gets better because you're about to... You now... If it's not this semester, it's next semester, you get to start picking all of your classes and pick things that are interesting to you. Pick things that are interesting to you. Okay. All right. Chad Huntsman tries to help him out again. And then, of course, Jamal doesn't fail. That's irrelevant to the claim, though. I mean, you can just see him in the side, like, yeah, but like, that doesn't matter and stuff. And Jamal says, no, it's entirely relevant. No, nowhere. Meyer would, in order to sue for damages, here we go, have to prove that he was kept from pursuing another deal, another publisher, and or frozen out industry-wide. No, he doesn't. No, Jamal, no. No. Oh, no. Since we know that Antarctic came to their deduction by their choice and have issued, no. And Chad, the Chad Huntsman versus the Virgin Igle. No. The claim isn't about being blackballed from the industry. It's specifically about Waid's call to Antarctic Press that he's already admitted to. Eigel comes back with the stunning retort. It doesn't matter. It doesn't matter. That's Wyclef reference for you 90s kids. It doesn't matter. Mark calling Antarctic isn't illegal. Immoral. I mean, a little bit. Or unheard of. That one I believe. Mark's an independent contractor. Irrelevant. Irrelevant unless he were an independent contractor for Antarctic Press. That would be relevant. That's the only way. It's the only way. Something but... Wait. Meyer claimed Mark was acting as a Marvel employee. Not in his complaint, you idiot. Only on social media, he said, maybe. And I don't even know that he did. I don't even know that he did. But here's the kicker. Mark may have been acting as a Marvel employee. We don't know. We might have an opportunity to find out on Discovery. I doubt it. I doubt it. But it's possible that he was acting. It really depends. But a lot of people have been talking about what Discovery can do in this case. Guys, there's a huge chain of events that would need to occur to get this to a point where they could discover emails between Mark Waid and Marvel. Let me be very clear about that. There is a logical scenario where that is possible. It is very unlikely. It has not been alleged in the initial complaint. It would have to be some amazing statement on Discovery or in depositions. Don't count on it. Don't count on seeing Mark Waid's emails with Marvel or Disney, okay? They may be there. We even if they are, we will probably never see them, but it is possible. Very unlikely. All right, don't get your hopes up. CMYK Comics says, "No, Jamal, no!" Now, wait a minute. I can't steal that from Ralph. That's rude. Can't steal that from Ralph. Casca52 says, Mark said, I offered to, once the dust settles, conduct an interview with him for publication. In interview. Is this compensation for doing as told? Sure looks like it, right? Sure looks like it. Once you go ahead and do this thing, I'll do an interview. We'll smooth this over. I'll give you some publicity. We'll get you some play. I'm a big name around here, right? I'm a big cat in this town. I'm a big cat in this alley. It sure looks like it. And if I were Waid's if I were Meyer's lawyers, absolutely would be on the menu. Absolutely would be on the menu. All right, next. All right. Meyer claimed Mark was acting as a Marvel employee, something both Antarctic and Marvel deny vehemently. Isn't it great when your employer denies that you're acting for them? That's just funny. But that's fine. That's fine. He doesn't need to. It's irrelevant if he worked for Marvel or not, except that it could lend to liability for Marvel. It is absolutely relevant if he worked for Antarctic, which he doesn't. Back to the Chad. Waid is alleged to use his pull with Marvel in the call. It doesn't matter if he's freelance or not if he's making threats with Marvel's name. I'm not going to give that one a pass. It matters if he's acting within the scope of his job duties at Marvel. Now, that could be broad, and you can make a lot of arguments about it. That's a long rabbit trail we're not going to get into at this point. If we get to that point in Discovery, you bet. We'll explore all of that. Okay, Jamal, come on. The Schadenfreude is great here. No, he didn't. That's where your failure to comprehend facts does you in. Let's see. Chad Huntsman says he's alleged to doing these things. That's why the matter is being taken to court. Do you know what alleged means, right? Or are you only capable of ad hominem? Brutal. All right, this should be good. This is where Jamal engages in a hypothetical. We've seen how good he is at analyzing the real events. Let's see what happens when the events are made up and the results don't matter. Okay, allow me to entertain your scenario. We have proof in writing from Antarctic Press stating publicly that they were under no pressure from Mark Waid. I'm not sure that that's proof, Jamal. That's evidence. Some evidence is good. Some evidence is not so good, right? It's not so good, okay? They were under no pressure from Mark Waid or Marvel Comics to cancel their deal with them. We have Mark's public statements corroborating their version of events. Mark's public statements are doing Mark no favors right now. Why do you think he tossed them all? Oh, and then Chad Huntsman. Okay, so you don't know what alleged means. Brutal. I can't actually like any of these things because this is not my main account. So back to Jamal. No, you don't know what the law says. You don't know what the law says. Mark, as a private citizen, has the right to call a business and express his concern about whom they choose to do business with. Maybe he does. Under certain circumstances, sure. It's not illegal, no matter what his celebrity in the industry might be. Those two statements are both individually wrong. Only Jamal can make one sentence have two completely exclusive incorrect statements in it. Marsupial Gamer says, Jamal Eigel, you don't know what the law says. John Russell, Your Honor, the police must be lying when they said they found the murder weapon in my client's dresser. He kept it under his bed. Yeah. Okay. Chad says, the suit isn't because of him calling as a private citizen. It's because of what he's alleged to say during the call. Maybe if you stopped eating paste, you could figure that out. Aw, come on. Come on. Now who's the one throwing out the ad hominem attacks? I'm sorry, my grasp on the legalities of the situation outstrip yours. The Chad literally came in with like the most polite, yeah, but that's not really important though. Which is actually true. And he's like, you don't understand the legalities, son. Let me wizen you up. Perhaps you shouldn't attempt it. No! Don't say it! Don't say it! Perhaps you shouldn't attempt to try and debate someone with nearly 3 decades of experience with publishing contracts. Who cares? Who cares? Are you writing them? Are you drafting them? Are you doing the continuing legal education to make sure you're up on the current law on contracts? No, Jamal, you're not. You're not. I don't think Chad is either. But that doesn't mean that you have a leg up over him. That's an appeal to authority, and it's not even a good one. It's a shame your experience doesn't translate to reading comprehension. Otherwise, you wouldn't be repeatedly making yourself look like a retard here. And that's a hard R retard. I don't think that's okay. Not in 2018, Chad. Yes, that's what's happening here. Allegedly. Got him. All right. All right. Oh, here it comes. Here it comes. My gaffer says, it's always funny when lay people pretend they know the law. Waid made false statements in order to get his publisher to drop him. I don't know what the outcome will be, but don't pretend it's obvious. Lay people. Lol. Buddy, you are the layest. I mean, are you a lawyer? As in, did I pass the New York State bar? No. I mean, yeah, but also no. No. Have I studied contract and copyright law and worked at a firm in the past? Yes. Jamal, let me help you. Let me quote Jamal Eigel. Do they know that Mark Waid's attorney is a tort law specialist? Tort law. Jamal, even if you did study contracts, even if you did study copyright, even if you're a world-renowned expert in those, but you don't know yourself some tort law, you're not really doing well with the tort law. Okay. Did you buy a comic about Eigel's adventures? No. All right. Worked at a firm in the past. Like, I keep seeing that he worked in the mailroom. I don't know where he worked. Is that true? Do we have any confirmation of what firm or why or what capacity he worked? All right. My gaffer. Obvious follow-up. Why did you focus on the irrelevant point in your reply? Absolutely. I'm not going to keep going with my... He's got right there. That's enough. Full stop. Let's move on. Spoken like a real Nimrod. Nimrod, a biblical... Pretty sure he quotes the Wikipedia article. Nimrod, a biblical figure as a king in the land of Shinar, was, according to the book of Genesis and books of Chronicles, the son of Cush, therefore the great-grandson of Noah. Thank you. You're welcome? I love it. Wow, I gotta quote the dictionary. Really? Lowercase Nimrod, not a biblical figure. You Nimrod. An inept person, idiot, jerk. Mithrin Emrys says, Jamal knows the law. He's watched LA Law, Matlock, and every episode of Law and Order, including the spin-offs. Darth Bobcat. Tort law. What's the big deal about knowing cake? You ask that guy out in Washington State or Oregon or whatever. He went all the way to the Supreme Court for knowing cake, buddy. Dr. Nerdly says 3L here. Gotta ask Themis, Kaplan, or Barbary. I did Barbary. Although I wasn't paying attention, and you're supposed to do Barbary for like months. I had to pound through Barbary in a couple weeks because I forgot it started. So, but Barbary. If I can give you some bar advice, personal. This is not binding. This is not helpful in any way other than this is my personal opinion on the bar. Hit those multiple choice tests as hard as you can. Leave the essay stuff for later. I don't know what state you're in and what your tests are, but to give you some perspective, the Minnesota exam, something like total of 60 points is your essay and 200 points is your MBE multiple choice. Hit 80% on your MBE and coast through your essays, buddy. You do that and you're fine. Do Barbary and just constantly take their stupid multiple choice practice tests. That will help you dramatically. Bagel Goose. I have great relations with the tort laws. All right. Hey, I don't come to your job and slap the broom out of your hand. I guess Jamal has something against janitors, which seems a little rude. So the Grays comes out. May we please see your law degree, Eigel? All right, here we go. Here, let's get something very basic right out of the way and help Jamal out. Guys, we almost need a GoFundMe to help Jamal. You realize, of course. Mark S. Zaid. He gives his middle initial for no reason. Zaid. Zaid would be fine. Lawyers are fine being referred to by their last name. Mark S. Zaid successfully sued the Libyan government for $2.7 billion, right? Wrong, Jamal. Wrong. He negotiated a settlement. Let's tweak that. He participated in negotiations for a settlement with the Libyan government. In international law, under Scotland's law, because it was the Lockerbie bombing. It was under Scottish law. He's an international law guy also. So his $2.7 billion settlement, which wasn't actually just him, several legal teams and lawyers and the pressure of the United States government all involved in that. Let's ignore all of the context for that and still say he did a good job. We'll also say that amounted to $10 million per family, and they only got 8. Which, I mean, good job still. But that has nothing to do with tortious interference with a contract under Texas law. You dummy. You dummy, you dummy, you dummy. Okay. Rick Nikita says, this sounds like classic Landwy legal theory. I think Landwy's been studying at the law school of Jamal and Twitter et al. Chuck Arden says, I don't go to Jamal's studio and tell him where to stick his pencil. Ooh. Ooh. You're welcome, Dr. Nerdly. You're welcome. Okay, anyways. Dick, which is Meyer, is effed because he can't show standing. Wait, what? What? All right. Let's see. Oh, this is con law stuff. This is separation of powers. Okay, I'm not going to do this. I was going to just sit and research standing real quick. Here's standing. Were you injured? Are you the injured party? Yes. Standing. Done. Done. Can you do you have subject matter jurisdiction over the other person? If so, does the court have subject matter jurisdiction over the claim? Tortious interference with the contract in Texas in district court which has diversity jurisdiction over the parties? Yes! Of course he has standing! Of course! He's the guy alleging damages, Jamal! Of course he has standing! Who do you think it's a private party suing a private party? Of course he has standing! He's in the frickin' jurisdiction, you idiot! Lucifer Love Monkey says, Jamal, Greer, or Landwy, you have to choose one. I'm going with Greer. I'm going with Greer because I think he'll show up at court if I pay for his Uber to get there. Landwy, I think, will be tanked, and Jamal will ruin everything. Oh my god. So of course he has standing. What are you talking about? And you don't have to be a lawyer to know a lawyer. Oh, thank God. Guys, if you had to be a lawyer to know a lawyer, I'd be out of business in a moment. I'd only be able to be hired by other lawyers. So wouldn't be able to know me if you're not one. Here we go, though. Here's the big flex. Here's the big Jamal muscle. Or in my case, 4. 3 of which are corporate lawyers and study business law. This is not a slam to corporate lawyers in any stretch. Corporate lawyers are fantastic at their jobs. And they have an interesting and different approach to law than trial lawyers, because trial lawyers have to make money off of people, and corporate lawyers make money off of corporations for doing a set of tasks and having a set of expectations that they follow, right? Like, you're going to make sure we're in compliance with this stuff. We're going to ask you questions about these things. You're going to review our contracts and internal documents. You're going to manage our communication policies and do risk assessments. Corporate lawyers tend to not go to trial. They sometimes do, but a lot of times a firm is going to hire outside counsel to do trial for all sorts of reasons that have to do with insulating the discoverability of their internal communications with their own counsel. Okay? Of course you're going to hire outside counsel. Knowing corporate lawyers means nothing about their ability to assess trial law issues. Because corporate lawyers largely don't do trial. They don't need to. It's not in their purview. That's like saying, I know 3 research attorneys. Great, Jamal. They can help you find citations all day, but they don't know how to influence a jury. They might not know the procedure. I know 3 civil procedure lawyers. perfect. They're great at knowing deadlines and doing all of that stuff. And you need all of these guys, like if you want a full-on thing. Being a one-stop shop is very hard. Very, very hard to spread yourself that thin. I would much prefer to have a specialist in every single area. Oh my goodness. Guys, the incompetence is blinding. Blinding. And yes, I have lawyer friends. All right. He also studied up business law. So, Thor Odinson, try looking up Meyer's lawyer. That's what you get when you go to Bleeding Cool of all places for your news. Exactly. Bleeding Cool, you're a hack. You're a horrific hack. I don't understand. Like, you don't have to like Meyer. I don't care. I don't care who you like and don't like and how you report. But when you're reporting about an attorney's credentials and you leave out the relevant ones, you're a hack. And it's easy to point it out. You're garbage on this article. Whatever you do on the rest, you might want to think about what you're stuffing in your throat there, buddy. 'Cause it's going to be apparent. All right, next. All right. Next legal opinion. Guys, I thought we'd be flying through these. I was worried that we might burn through these super fast. Oh, gosh. Spike Strat 13. Jamal Phoenix wrong. Okay, so this guy posted a picture of iron sights. Jamal's expert opinion. All that shows is he self-published a book. I think that was the point. It has nothing to do with whether or not he can show standing. Irrelevant. Whether or not he can show standing has zero impact on anybody, Jamal. He didn't cost Meyer any money. I'm sorry. Okay, let's clear another thing out of the air. Meyer making money subsequent to having his contract removed, which he hasn't yet. Okay? Because his contract with Antarctic Press was for a subsequent run of Jawbreakers that would be distributed through Diamond in the traditional distribution channels. Notice how he has not put out a comic of Jawbreakers through the traditional channels because his contract to do so was destroyed. So it did cost him money. He did cost him money, you giant idiot. It cost him 50% of whatever shipping and sales would have been under the terms of the alleged contract in the case. So yes, it absolutely cost him money. Him publishing Iron Sights had nothing to do with that Antarctic Press. And you can't point to his earnings on Indiegogo because that's separate to the other contract. The Indiegogo campaign wasn't part of the contract with Antarctic Press. Okay. Antarctic had every right to cancel their deal with him. No, if they have a contract, they don't. You give up those rights. That's how you make a contract. I thought you studied this. It's an exchange of rights. It's an exchange of rights. I give up my rights to do this, and you give up your rights to do that. I give up my right to my car, and you give up your right to your money, and then we trade those. There you go. I give up my right to not create a comic book, and Antarctic Press gives up its right to not print it and ship it. You moron! They don't have the right anymore once there's a contract! Okay. He didn't prevent Meyer from taking Jawbreakers to another publisher. First of all, they didn't directly do that. Second of all, that's irrelevant. And third of all, they may have indirectly done that. Because every other publisher now knows that they're going to have to take a call from Mark Waid. And who on God's earth wants to take a phone call from that insufferable pile of trash? Anybody? Oh my gosh. I hope he calls me so I can hang up. Good Lord. Next, That's not how law works. Thank you, Cypher TV. Perfect, succinct, brevity is the soul of wit and wisdom. Let's find another Jamal. You're not even worth a playful, snarky remark. So here's my playful, snarky remark. You ain't even worth it, bro. Here you are. Next. Okay, that's not a legal opinion. All right. Next. This rat effer. If you guys don't notice, if you're new here, I don't really use profanity. This rat effer has apparently been deleting tweets. Too effing stupid to realize that they aren't actually deleted, and Twitter will turn them over in the discovery process of a lawsuit. I hope Waid countersues this Nazi F into the poorhouse. Maybe they'll turn them over on discovery. Maybe, if it gets there, and even so. I don't think he's deleting tweets to try and hide them from the lawsuit. Zach has, I'm guessing, no illusions that his stuff has been snipped and saved and put into the SJW blacklist file for all of eternity. Okay? You guys still refer to a private monetized video that was not made public by him long after the fact. I don't even know when he did it. Long after the fact, okay? He knows that you've copied all of his tweets that you don't like, and you sit there crying onto them and wiping your tears with them all day. He knows that. I'm guessing. It doesn't really matter, though. It doesn't really matter. And if Twitter turns them over, good. Twitter should do that. And guess what? They're going to turn over Wade's also. Spike Strat 13. Better not call Jamal. Wonder if YouTube has deleted videos too. Yes, absolutely they have deleted videos. Absolutely. Speaking of which, guess we have... I have screenshots to give to Waid hashtag. Or I need that. Good. Yes. Send them all to Waid. Guys, every time... you just send them directly to his attorney. That's probably a good idea. Yes. All of Mark Waid's fans who may see this... go ahead and send those screenshots directly to Mark Waid's attorney. Just do that. You just bypass Waid. Send him there. That'll help. Fighting for the cause. The more you know. Okay. So we've exhausted that thread. Let's find the next one. Because there's one where he engages with the comics lawyer chick. And I want to get to those. Because they looked very spicy. It looked very spicy. Okay. Here we go. Was it here? This is timeline stuff. Okay, here we go. Let's check out these. These are not Jamal Igle. This is learned opinions from Dusty Good. Okay? Waid is going to win. No contest. The second his lawyer points out the previous harassment is a legal claim. They haven't proven harassment. They would have to allege it and then assert sufficient facts to pass the more likely than not standard of evidence, at least. Slander, again, and libel, again. These are all legal claims that have not been proven. They're not presumed. They would have to make a case for these things, which would be very hard. Because, never mind. It'd be tough. Which happened long before this allegation. The court is going to laugh Richard out of the courthouse. Oh, yeah. That's what courts do. Hey, guys, you know what? A convicted pedophile can sue someone and win without being laughed out of the courthouse. In fact, a convicted pedophile can sue someone for harming the convicted pedophile's legal child and win. Shockingly. You guys act like courts don't deal with bad people, and by the way, much worse people than Richard Meyer. What you've built this fantasy where because you don't like him on Twitter, he's literally Hitler. You've got this fantasy where he's murdering Jews in the street or something. I don't know. I don't know what is going on in the dark recesses of your mind. But the judge who's hearing this case has let a murderer go. I'm betting. I don't know that. Has let a murderer go. Has acquitted a rapist, an accused rapist. By your standards, the accusation would be enough to put them to the death penalty. And he has let him go. Okay? They deal with worse people than a guy who said mean things in a YouTube video about a bunch of comic artists that no one cares about. What world do you think this is? These guys have murderers, terrorists, rapists, child molesters. They have the worst people on earth in front of them every day. And you think they're going to be mad because he called someone a cum dumpster? You dumb cum dumpster! That's what you think? Jeez! They're words! They're words! These people deal with people who stab children to death! And you're worried that they're going to be mad about his words? My God! Guys, I'm going to shoe on head and start ripping my hair out and eating it. You have to remember that Meyer has to establish a clear case that Mark is 100% at fault for all that he's charged Waid with. No! 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 It's civil court. It's preponderance of the evidence, you idiot. It's like 51%. It's 51%. This is the base. It's not criminal court. It's not beyond a reasonable doubt. It's preponderance of the evidence standard. You giant moron. Oh my gosh. 51%. More likely than not. Myers has to prove the loss in his income is entirely Wade's doing. No, he doesn't. With Myers' track record of tweets, videos, and other comments, he can't do it. What does his track record of tweets that predate the event have to do with his ability to prove damages afterwards? Richard Myers is the biggest detriment to his own case. It might be true. That's probably the only smart thing you've said. Meyer probably is the biggest detriment to his own case. Oftentimes, the person suing is the biggest detriment to their own case. That doesn't mean anything, and it doesn't mean he has a case. It's also a relative claim. So the other detriments can be really small. Let's see. I have no idea how it works in your country, but I hope Waid is able to do him for costs after the inevitable victory. Apparently, they have rape retribution for lawsuits in whatever country John McGavin's in. Seems rude. All right. Let's see. All right, so we're done with that one. Let's see what's next. I can't wait to find that other thread. Boring. Some hot takes on Jamal's feed, by the way, if you're not there. Never go full Lindsey Graham, y'all. You know, on a side note, no matter where you stand on Kavanaugh, no matter where you stand on Republicans versus Democrats or Trump or even Lindsey Graham, never go full Lindsey, as Lindsey Graham just solidified votes from the Republicans who hate him. Yeah, never do that. Never do what Lindsey Graham did and appeal to the part of your base that hates you and would think about primarying you, except you just defended Brett Kavanaugh when that's all they've wanted someone to do for like the past 2 weeks, and you did it, and they're memeing you with laser eyes. People who were making fun of Lindsey Graham 2 days ago are memeing Lindsey Graham for being a Dragon Ball Z character going Super Saiyan. Never do that, guys. Never appeal to a bunch of people who hated you and convert them with a 3-minute rant. Never do that. Never go full Lindsay, you flippin' idiots. Never bring a Nerf gun to a knife fight. Now, I've checked on this one. Unfortunately, it's not directly related to the lawsuit. I bet it is actually related to the lawsuit, but I'm not going to go into it. Let's see. All right. Boring. Oh, here we go. There's more responses. Part of Meyer's suit is claiming defamation of character as well. There's so much evidence in Wade's favor. The arbitrators, this will never go to trial. What do you think this is going to go to arbitration for? Okay, so guys, many, I don't even know. Many or most jurisdictions do have some requirement for an attempt at alternative dispute resolution. You know what's not mandatory? Arbitration. Usually you have to submit to an arbitration agreement. To have binding arbitration be a part of your alternative dispute resolution. My guess is that their attorneys would agree that mediation is probably the preferred alternative dispute resolution method, especially given the hostility of the two parties, because they can walk into the mediation room, swear at each other, and then justify leaving. But in arbitration, they both have to, someone has to pay for an arbitrator. Who's going to do that? Waid? Is Waid going to do that? They don't have an existing contractual relationship with an arbitration agreement, Jamal, expert of contract law and business law. God, you're stupid. They don't have that. So what do you think a court's going to do? Force them to arbitrate as opposed to mediate or just negotiate on their own terms? Why would a court do that? You expert, please enlighten me. The arbitrator's head's going to spin like Linda Blair in The Exorcist. Sure it will. Sure it will. Let's see. Where is it? I should have just kept that one open. Oh, here we go. This one's gonna help. This is for Love Monkey. That was the dumbest thing I've ever read. Kaitosora, yes. Go to law school, tell him you read all of Daredevil. Tell him you also did it while blind, and then you're an extra special lawyer. All right. I love how people saying you're not a lawyer somehow means I neither understand the things I'm discussing because, shocker, I have some experience with contract and copyright law and can read the law for myself. Then why haven't you? Why haven't you read it if you can do it? You keep, you're not convincing me, Jamal. If you can read it, go read it. And most importantly, talk to lawyers. They exist, except when you don't like them, right? Then you just block them on Twitter and pretend they don't exist. Because I'll tell you where you're wrong over and over, and I'll do it in a polite and respectful manner. Not anymore, obviously, you turbo cuck. Obviously, it's that deal sailed. That deal sailed. I took pity on you at first because I thought you were just an idiot and spouting off about some field you had no knowledge of. And then I found out you were actually confident in your positions, and my life got 100 times funnier for it. Thank you. Thank you. Lawyers do exist. Yes, you're right. They do. You should talk to some. They'll blow you out, pal. All right. Let's see. Thanks for the opportunity to blatantly plug my already incredibly busy failing career. Yes, you had the opportunity to do that tucked in a thread that no one's reading on your own page. Jamal, more people read that watching my live stream than read it on your Twitter with your 0 likes. You idiot. You're welcome. I just shilled your book to live 450 people and post live who knows how many. Way more than will ever read your obscure tweet. Good job. Good job shilling your product. Okay. Oh gosh, I can't read that. Where are we? Where are we? Where are we? Let's see. Except they already dropped the book before Mark called. Wrong. Hashtag wrong. Good job, Gail Simone. Hey, Gail Simone, come on my show sometime. We can talk about this. It'll be great. It'll be great. And before you discount that, I treat every guest with the utmost courtesy and respect. I have interviewed a pedophile on this channel, a convicted pedophile, who also said several very horrible things about me. And I treated him with, I think, a tremendous level of respect and probably surprised a lot of people. I would do the same for you. So Gail Simone, if you ever want to discuss this in a civil manner, come on my show. We can talk it out. Jamal, you too. Okay. Antitrust. So here we go. Guys, even in Jamal's hot takes where he's partly right, he's still wrong. He's still wrong. I also love they keep trotting out antitrust laws, except that according to the Sherman Antitrust Act, it only defends against monopolies. No, it primarily defends against monopolies. But it also doesn't just defend against monopolies, Jamal. Read section 2. It's all the way in the second paragraph of the act. Let's see. Wait a minute. Where do we go? Proof of loss. Where he said he was an IP lawyer or something like that? Hold on, I lost it. Guys. The boomerism. Oh, wait, no. So I want to follow this tweet. Oh, here we go. Yeah. IP law doesn't cover it. I've already gone through the FTC Acts of 1914, the Clayton Act, and another post. Oh, gosh. Hold on. Give me a moment. I'm sorry. Cammy Killer says, notice the 40K books on your booze shelf. Thoughts on Caiaphas Cain? Love the channel rackets and loving the content variety recently. Keep it up. I have not read Caiaphas Cain. I do have it. It's right there. You can't see it, but it's up there. Okay. I cannot go through those. Because I studied copyright and trademark law in college. Have been involved with contracts and publishing, marketing, books, comics, book publishing, and advertising for almost 30 years. I swim in this stuff. Jamal, why are you drowning, buddy? Why are you drowning if you swim in this stuff? Here we go. For the worst take Jamal has to date. Guys, he quotes the law and gets it wrong in the same tweet. All right. Let's read his quote first. To prevail in a lawsuit for intentional interference with contractual relations. Mind you, this is not from the District of Texas. I could tell because of the language. Because intentional interference with contractual relations isn't the cause of action in the Western District of Texas. It's tortious interference with a contract. And that doesn't mean much. The standards are very similar. But Texas is a 4-part test. Notice there's a 5-part test here. Either way, he's still going to get it wrong. He's still going to get it wrong. That's how sad this is. Okay. To prevail in a lawsuit for intentional interference with contractual relations, the plaintiff must prove a valid contract between the plaintiff and a third party. Plaintiff is Meyer, third party's Antarctic Press. Okay? Keep these in mind. I don't know if Eigel can. The defendant's knowledge of this contract. The defendant is Mark Waid. Okay? Mark Waid. The defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. Now, Jamal, I know this is max headroom stuff. You better be large craniumed for this, my friend. But the contractual relationship is referring all the way back to 2 clauses ago under bullet point 1. The valid contractual relationship between the plaintiff and the third party. Not Mark Waid. Okay? Defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. 4. Actual breach or disruption of the contractual relationship. And 5. Resulting damage. The claim requires the existence of an underlying enforceable contract. Jamal, that's between your boy Zach and AP, not Mark Waid. Okay? In case you didn't get that. Where there is no contract or the contract is unenforceable, the plaintiff will only have a claim for interference with prospective economic advantage. Note, the plaintiff will still have a claim for interference with prospective economic advantage. So even if you're wrong about the contract part, they'd still have a claim. I guess you missed that line too. But let's read Jamal's hot take. Unless Mark has a contract with Antarctic, tortious interference would be very, very difficult to prove. Wrong! Wrong! And the dumbest part is it's the exact opposite. It's the opposite. If he had a contract with Antarctic, he would have a legal reason to contact Antarctic and tell them about this contract. Since he doesn't have a contract with them, he doesn't have a legal reason to do so, and he eliminates an affirmative defense. You got it as wrong as absolutely possible. In your own quote, you're the worst person to be commenting on law online, except for how redeemingly funny it is that you're so inept. You're so bad at it that you can get it wrong. You didn't strike out in T-ball. You died at the plate, Jamal. Akazit, first time tuning in, totally worth it. Thank you. Thank you, my friend. Thank you. Let's see. Let's see what happens next. Lucifer Love Monkey says I was wrong. This tweet is the dumbest. Here we go. Here we go. Someone called him out on it, and he responds. Miss Simone and Mr. Eigel, I hope the lawsuit that's been filed helps you reflect on the ethos of the opposition to DC and Ethan. Also, Mr. Eigel, look at how respectful this guy is. He doesn't deserve it. He doesn't deserve it. He doesn't treat people with dignity and respect. He treats them like trash. You don't have to be polite. You don't have to be polite. Yorgamunda07, gotta sleep, but future me thanks you for the great video that will get me through work tomorrow. Thanks, buddy. I appreciate it. I really do. I really do. All right. So then, now, he replies with this, which is irrelevant to his initial point. Irrelevant to his initial point. Hang Solo says, anyone wanting to be in Comicsgate doc, please DM me. Okay. Okay. I don't know what Comicsgate doc is, but you should do that. All right. So facts. This is from Antarctic Press. Mind you, this is after Antarctic Press put out a tweet saying right after Mark Waid's call that they canceled the contract because of trepidation over the massive forces, and they know it was a contradiction of their own policy about promoting artists and separating the art from the artist. You know, that tweet is down the memory hole for these dummies. But they've got this one. Facts. Mark Waid put a call into our office. Fact. Fact, fact, fact. Look, you stupid idiots I've been arguing with all day on Twitter. The two of you, whose names are so ridiculously unimportant, I can't even think of them. It doesn't matter. You keep saying alleged that he put a call in. AP and Mark Waid multiple times confirmed the call. Why do you hang on to this? What are you swinging from here? It's the dumbest position you can take. Of course he made the call. He said he was going to. He gloated about it afterwards all over the internet. Like just a rabid dog running around marking every stupid blog who would listen to him. And then you've got AP confirming the freaking call. Staff took a message and told Mr. Waid our publisher would be informed. Nobody at AP contacted CB Cebulski or Marvel, nor felt threatened in any way by Mr. Waid's call. We have not been bullied into a decision by any Comics Pro. Yeah, that's great. Also, funny story. AP subsequently tweeted that the person making this tweet wasn't authorized to do so. I mean, you know, that tweet exists too. You idiots. You can't just memory hole everything. Let's see. Okay, she's right. Oh, who cares? Who cares? All right, so there's that. Let's see if there's anything important here. You would need to show cause of action. No. A cause of action is a noun. It's a cause of action, and that is when there has been an alleged breach of a law, you have a cause of action. You don't need to show cause of action. That's something different. I don't even know what that is. Okay. This statement is kind of right. Your case must conform to a recognized cause of action. It's kind of right because sometimes there are novel issues for the court that are not recognized that you still win on. So, no, not quite right, but D for effort. Let's see. Let's see. Here we go. This is rich. There's no defamation or slander because as previously reported by the Daily Beast, BuzzFeed, and now Bleeding Cool. Listen to that laundry list. Meyer's own history of well-documented targeted harassment would be brought up as a reason not to carry his product. Doesn't matter. Jamal, talk to a lawyer, not to a journalist. Because I'll tell you something. Journalists ask lawyers, good ones, good journalists ask lawyers for legal opinions because they don't know the law. They don't know the law. All right. This is a bit of a straw man. Absolutely. Oh, good. He posted the same thing again. Tortious interference requires Mark having a competing contract with Antarctic Press. Again, he does it again here, guys. No. And it's the same thing. No, that's wrong. And this guy lays it out for him. Valid contract between plaintiff DNC and a third party AP. Half true, validity unknown. No, the validity's known. Guys, let me help you. DC says, we've got AP doing this. Public tweet, right? AP is going to publish Jawbreakers. Happy to be working with him. AP says, we're doing it. Happy to be working with DNC. We're publishing Jawbreakers, suckers. Oh my gosh. Like, if that's not evidence that these two have come to a meeting of the minds, Jamal, in your contract class, did you discuss this? That they have actually created a contract. Whether or not there's a piece of paper doesn't always matter. Oral contracts are enforceable in Texas. So are email-based contracts. Okay? All right. Next, defendant Mark Waid, knowledge of the contract, true. Defendant Mark Waid's intentional act in dispute. Breach of contract between plaintiff and third party, AP, true. And damage undetermined. All those conclusions are wrong. Mark would be the third party. Yes. No, sorry. Mark is the defendant, you dummy. Mark is a third party to the contract, but Mark is the third party tortiously interfering. Like, honestly, who liked this? Oh, wow. Anyway, not good. Not good. Not good. Okay, what's next? What do we got next? Here we go. He even quotes it. He even quotes the... Just so that you're clear, he says. After careful consideration, it is a decision of Antarctic Press to not release the comic series Jawbreakers. Antarctic Press is a staunch believer in creators' rights and giving creators a chance to showcase their creation, allowing that creation to be judged on its merits. Many forces, many of them, should be viewed with great trepidation about how our society acts, have led us to this decision. That's a bad grammatical statement. It says many forces have led us to this decision, and it also says many forces should be viewed with great trepidation about how our society acts. We do not take this decision lightly, as we do believe that there should be a separation between art and the artist, and the separation has been blurred in our decision. We appreciate all our supporters and detractors in this process. I'm sure you appreciate those detractors. Why? Thank you for taking the time to read our statement. This statement will be removed in 7 days. This was right after Waid went on his stupid announcement spree. Jamal, this isn't helping. This isn't helping you at all. Next. The devil's in... Oh, here it is. Here's Ladies Making Comics. Here's Ladies Making Comics, guys. I've been trying to find this. Ladies Making Comics. I know nothing about her. Nothing about her. Her, I assume it's a her. Maybe I shouldn't do that in 2018. Other than she states that she is an attorney, a lawyer, whatever, in Washington who only wants to talk about comics and comics issues. I respect that. That's fine. So this is a presumably learned person. Now, I don't know the extent of their knowledge of any of these issues. None of this is intended to imply that Ladies in Comics is not a valid lawyer or anything like that. But I can tell you right off the bat, I have some big disagreements with this person about the law. And we're going to focus on those in just a second. All right. Lawyer to lawyer. Ladies Making Comics. And I'll try and not call you sweetie, because that's rude. I guess. Most of comics Twitter right now. Now that douche nozzle will be told he sucks by a court of law. You're right. That's what's going to happen. Meyer's going to be told that he sucks by the court. Maybe. Judges do say some pretty mean things sometimes, and it's kind of funny. Okay. Real quick, Troy Thompson, thank you so much. He says, Jamal, though funny, is the deadest of horses. Now do Ladies Making Comics. She has actual legal thoughts. The timing is impeccable because we are moving. We're moving right into Ladies Making Comics. And I'm probably going to go to her Twitter in just a second. All right. Okay. Okay. We're getting a little deep in the stream, and I'm going to have to work real hard not to insult this person too much. Okay. Me right now. OMG, it's incredibly possible that he only had a unilateral contract. Oh, really? Oh, really? Guys. Let's talk unilateral contracts. Okay, this is deep dive into contract law. And I hate contract law. So, please do a well check on me later. Don't do a well check. That's a joke. It's a joke. I hate contract law, and the minutia of it is really thick. Bear with me for a moment. A unilateral contract. A unilateral contract is where one party unilaterally establishes enough stuff, we'll say. Enough terms, consideration, and understanding for any party, anybody, to walk up and say, I accept, and take it. That's a unilateral contract, okay? Guys, when you go to the store, which, let's walk through the process of the retail environment in the United States. You walk in the door. You grab your shopping cart. You're at your Walmart. Someone says they love you. You walk past them and you go to the shelf. You pick up your package of bacon, because that's why you're at Walmart at 2 in the morning, is you're hungry for bacon. You pick it up. It says on the little tag, $3.25, because you only buy the cheap bacon. You put that in your cart. You walk to the register. You walk to the automatic checkout register, okay? Bear with me. You walk to the automatic register. You scan that sucker in. You throw it in the bag. It beeps at you for like 10 minutes because it can't find out that the bacon's in the bag on the shelf. Finally accepts it. $3 and however many cents. I already forgot. Doesn't matter. You put in your credit card. You hit pay. Pop quiz. Was that a unilateral contract? Was that a unilateral contract? Pop quiz. Anybody. Press 1 for yes. Press 2 for no. In the chat. And I'm waiting. 1 for yes. 2 for no. Pop quiz. Go. I like the 3s. Notice the answer. This is why everybody hates contract law. 2, no, that is not a unilateral contract. That is a bilateral contract, and you, unbeknownst to your normie, non-legal self, negotiated the terms of that sale. You negotiated for that price. Now, I know you're thinking, I just walked in the store, walked up to the shelf, picked up a piece of bacon. I walked to the register. I didn't talk to a single soul because, dear Lord, you don't want to talk to Walmart employees at 2 in the morning. I scanned it. I put it in my bag and I paid what they told me. You negotiated that sale. That's a number 2. No. Ladies making comics, if you're a lawyer who does anything with contract law, you have to know this can't be a unilateral contract because no one on earth can walk up to Antarctic Press and say, I accept, and get the same terms that Zach had worked out with them through several emails. You dummy! You stupid person! No, that's mean. That's mean. You wrong and incorrect lawyer, you! You should know better. You should know better. Unilateral contracts are so ridiculously difficult to prove that they almost don't exist. This is ridiculous. You people, what is your ideological affiliation with Waid? How is it so strong that you collectively lose 40 chromosomes? I mean, oh my goodness. What is wrong? Yes, that makes you dead. I get it. You unexist yourself. Seriously. It's not a unilateral contract. God, to my law student friends out there, if the test question says, is this a unilateral contract? Just check no. You're like 80% likely to get it right. And that's in the law school context. In the real world, I mean, like the situation that brings about a unilateral contract is, it's almost unfathomable. It's a thought exercise. No one has it. No one has it. Because it literally means that someone can walk up to you and say, I accept, and if you don't do what they ask, they can sue you. We don't do these. We don't do them anymore. We don't do them. I don't know what technically a lawyer is. Okay. All right. Okay, here we go. Next hot take. Next hot take from the lawyer. And, I can't do all the emotes, guys. If he launches Indiegogo even a minute before discussion started, he can't even get them on promissory estoppel. Why on earth would he claim promissory estoppel? Why would he claim promissory estoppel? Oh, in his case against Waid totally falls apart, but whatever. Oh yeah, you're bang up 2 for 2 right now, you dummy. Promissory estoppel doesn't apply here. Dan Montgomery says, this kicks the poop out of daytime soaps. Thank you. Thank you, my friend. Promissory estoppel is a theory at equity. A theory at equity, because it's not a contract, okay? A theory at equity, where one party makes a promise intended or reasonably known to induce another party to a particular action, okay? And then the other party undertakes that specific action to their own detriment, and even then, you're throwing lawn darts at a whale's blowhole off the coast on if you're gonna win promissory estoppel. Why on earth are you bringing this up? No one is alleging promissory estoppel, and if Zach's attorney had alleged promissory estoppel, you'd all be right that he was a dummy. You'd all be right about it. No one is claiming this because there's no way on earth anyone thinks this is promissory estoppel. Guys, promissory estoppel is a grandmother saying, you know, I promise after you marry your bride, I promise to give you $50,000 down payment on a house the day after you get married. So go ahead and sign the documents now before you get married. Because I promise to give you 50 grand for a down payment. So you just tell them you've got 50 grand in the bank. I promise you don't have to do anything. You don't have to do anything to do this. So forget the day you get married. Let me get rid of that, because that makes it seem like they have to get married. I promise on March 12th to give you $50,000 in a down payment for the house. So you go ahead and sign that, and you can set the closing date as March 12th if you want to. Because on March 12th, I'm giving you 50 grand to promise. As a promise, I'm giving you 50 grand to down pay that house. And then that guy goes, yeah, okay, I'm going to give up $10,000 in earnest money, and I'm going to promise them a 50 grand down payment on March 12th. That's our closing date. Grandma doesn't deliver. That's promissory estoppel, because now this guy just lost 10 grand in earnest money when he breached the contract. That's it. That's it. You try and find another example of promissory estoppel, you're talking about employers promising employment to people if they move across the country and quit their other job, like that they're gonna go ahead and employ them for 12 months and then they don't. We're talking seriously specific stuff. What are you talking about? What are you talking about? Wonder if she submits motions with the emojis. These people are beyond it. They're beyond it. And look at this. Look at this law expert circled shirt going on here. If the timeline is correct, he didn't approach Antarctic until his Indiegogo campaign was fully funded. It doesn't have anything to do with the Indiegogo campaign, you idiot. It's a separate contract for a separate run of books. A separate run of books. And creating an Indiegogo campaign wouldn't rise to promissory estoppel, because what damage do you incur in creating an Indiegogo campaign? What burden have you undertaken? What loss have you suffered? You freaking idiots! There's nothing to do with that here. You're too dumb to even see how ridiculous your stupid red herring arguments even are. You're too busy hand-jobbing each other over how smugly smart you are, and you're the dumbest people in the room. Okay. It only gets better. His official complaint is ambiguous about when exactly he started discussions with AP. While that kind of ambiguity isn't uncommon in its initial filings, it is curious to say the least. No, it isn't. No, it isn't, because your two stupid harebrained legal theories aren't in that document. So you're looking for evidence for promissory estoppel and unilateral contracts. Why didn't you find them in a document that doesn't allege promissory estoppel or a unilateral contract? I don't know. Maybe because it doesn't matter. Why can't you? It's curious. It's not curious. The only curious thing is why you're so dense that you think that these two issues would have anything to do in this case. What is clear is that he didn't even think he and AP had a deal until after he started his IGG. Of course not. Of course not. Only when he had guaranteed sales totaling over $400,000 or whatever did he think, hey, maybe, wow, people want to buy this in droves. Maybe if I release this on a massive channel, other people will want to buy it. Oh my God, what a novel concept. What a dummy. The devil's in the details. No, the devil's in how stupid you are. The devil is whispering in your ear to make these ridiculous arguments for the whole world to mock you. Grayscale Plaid says, do you think Nazis should be regarded as libel per se? No, I don't. I don't think it should be libel per se. I do think it could qualify as libel. I really do. But I don't think it should be per se libelous. All right. Look at this. I mean, guys, I scroll down and it only gets dumber than this. It only gets worse. I'm just happy because it means he will likely, no, not likely, never, not at all, 0% chance that this is required. 0. Put it on record. That he will finally have to produce a budget to show specifically what all that IGG money was intended for in the first place. What? What are you talking about? Profit! Hashtag profit, dummy! That's all it is! Indiegogo is profit. I'm gonna give you this. Here's how much it costs. Here's a payment platform, an intermediary for you to funnel your money into my fat gullet. What are you talking about? Why would he have to produce a budget? What on earth would make him produce a budget for hashtag profit? You stupid wench. What are you even thinking? Dear Lord. Guys, I'm melting. I'm literally allergic to being hot, and rising blood pressure makes me warm. I'm actually allergic to how stupid these people are. So if you start seeing little dots on my forehead and face, I'm honestly having an allergic reaction to the idiocy on display from this lawyer. What is she talking about? Book of Dano, the rage is flowing in you tonight. Buddy, it's getting stupider by the minute. Let's just migrate over to Ladies Making Comics and see if she gets smarter. Whew. Oh. Ryan English, luckily I have a big single level house and they're on the other end of it. Ultron 1 says, if only Zach were as stupid as these guys, the case would be an absolute slam dunk. Akazit says, Rekieta Law, literally allergic to stupid. I mean, I'm dying. Okay. All right. Let's see. It's warm. It's warm. I am as red as my shirt. It's warm. Should have opened a window. All right. So, what is she talking about? OGD. The Lord's name in vain. How dare you? He's not suing AP for breach because he thinks if he takes down Mark Waid, AP will welcome him back with open arms like he's effing Beowulf after slaying Grendel. I mean, why would he reward... I mean, I guess he's proud of Beowulf for slaying Grendel and that's why he'd want to sleep with him? I'm not sure what she's talking about here. That's what this AP is a victim narrative is all about. AP isn't a 35-year-old publisher run by a capable professional. It's a tiny, easily frightened baby deer. Make the man who scared them go away and you'll be their hero. No! No! Do you honestly... Is this in your head? That Meyer thinks after he shows that AP cost Mark Waid thousands of dollars. You think he thinks he's getting a contract with AP after this? You honestly think that? That's your plan? Ryan English, I'm melting from how stupid these people are. Lol. So you have three options after anticipatory repudiation. Yeah, lace it with the big words. 1, sue them. 2, graciously treat their repudiation as rescission and move on with your life. 3, beg them to reconsider. Though you can still do 1 later if they don't. He's not doing number 1 or 2, so... No! 3 doesn't logically follow from him not suing them. She's been on this stupid kick all day. She's like, he should sue AP. Why isn't he suing AP? He should sue AP. Here's a thought, dummy. He doesn't want to spend another $10,000 to $15,000 retainer to sue AP. Maybe that's his primary motivator. 2, he knows that AP's a tiny publisher with no money to get. Oh, in before your dumb argument, he can sue him for $1. Who cares? It doesn't matter. Why would he spend 15 grand to sue him for $1? Meyer isn't being supported by like the ACLU who's running his case for him for free. He had to hire somebody because this is the free market. And the guy he hired is a senior partner at a prominent firm in Austin. It's at least a 10 grand retainer. And to sue another party for $1 would be at least another 10 grand retainer. And if they go to trial, you know it's $50K. Each. Why would he do that? What stupid, harebrained world do you live in where there's no real cost for anybody? You say you're an attorney. Do you bill clients? What do? Do you just clerk? That's cool. Do you have no idea how this business works? Daniel Byrne or David Byrne or whatever stupid name is gonna charge. If this goes to trial, he's charging Zach $50K. I promise you, it's $50K or more. This is gonna take a year. This guy's rate, I don't know what it is, but I'm guessing it's $400 plus an hour. Maybe $500 to $600 an hour. He's in Austin and is a 35-year trial lawyer senior partner. It's gonna cost a fortune to hire this guy to do another concurrent suit simply to prove that a contract exists, because that's her stupid theory. Well, if they sue them for breach of contract, then they can take that and show that a contract existed and was breached. They don't need to. They have all sorts of evidence that a contract existed, and we know it was breached because AP said it. AP admitted they had a contract and then admitted they backed out of it. None of this is necessary, you dumb hack. What are you talking about? Why would he spend 50 grand to prove something that he's already spending 50 grand to prove? My God. None of these people live in reality. None of them. Sam Piter. What makes you more frustrated? This goofiness or Napoleonic civil law? Because them silly Frenchmen in Quebec and Louisiana come close. Oh, I don't even want to deal with that. Don't even want to deal with Napoleonic or Roman law. No, thank you. No, thank you. None of these people have any idea what they're talking about. It's crazy. It's crazy. Next. All right. Let's start seeing some tweets. Lord, how his face must have lit up when his employer told him about option 3. Yeah, I'm sure that's the first thing. Burns like, maybe after all this is settled, AP will take you back. And Zach's like, really? Really? You think so? You think they'll take me back? Like, oh my God. What? Pretend world. Pretend world. If he accepted their repudiation as rescission, then the contract has been terminated and there's been no breach. No. He clearly hasn't accepted their repudiation as rescission. He hasn't done that. He's alleging a breach. He's alleging and stating that they breached. Why do you think he would accept it as a rescission as opposed to a breach? What is making you think this? What is the technical means of accepting a repudiation as a rescission? Orally is acceptable as long as the contract doesn't say otherwise. Oh, yeah. That's good. Oh, duress rescission made under duress is invalid. If he wins this case in a way that proves they acted under duress, and theoretically that means the original contract is still open to option 3. I don't even know what she's talking about. We're going to skip it. I literally have no idea what claim she's making there. Let's see. Here we go. Oh, this sounds like this will be good. he's been trying to dial it back ever since, around the time he would have hired his lawyer. So what? So what? Even if he dialed back his stuff now, it wouldn't change what is happening in the instant case. As someone with a 177 on my LSAT and my golden for Ivy/T 14 tier, my GPA is Yeah, dude. You're good. You're in good shape with a 177, buddy. I don't know if you're good for Ivy League. I don't know what they're weird. Because, genuine question, and I don't mean this ironically, are you a minority? Because if you are, it's going to help. It's going to help. And if you are, great. If you're not, also great. 177 is a killer LSAT score, buddy. Good job. Good job. Apply wherever you feel like applying with that score. And then if they don't accept you, visit their campus and poop in their bathrooms. Guys, if you're trying to get into any law school, tangent, because I got to calm down. Tangent. If you're trying to get into any law school, you got your LSAT score, you got your undergrad and all that stuff done. You apply to the law school. Let me help you. Call their admissions department, which is like 4 or 5 old ladies. Okay? Call their admissions department, set up an interview with one of the admissions counselors, maybe the dean of admissions, depends on the school. Set up an interview. Go in. Dress nice. Not a suit. If you could do a suit if you want. You don't have to. Just dress nice. Be cordial. Be interesting. Tell them your story. Okay? Tell them why you fit in their law school. And then guess what? Say, you know what? I applied to your school. Really thankful for your consideration. And then go home. Make sure you shake their hand, smile, tell them your name when you meet them and when you leave. And any other time you can. And then guess what, guys? When they pick up that application, there's going to be like 5 of them. And they discuss your credentials and they discuss your letters of recommendation. Say, oh, you know what? That nice person came in. I talked to them. They seem really level-headed. Told me about their story. The crazy upbringing or whatever. Funny story about how they lost their shoes on Christmas. Who cares? Put your name up here with a face. You've increased your odds of getting into that law school by like 2,000%. I don't care what school it is. Okay? Do it. Do it. There you go. If you don't own any nice clothing, take some from a homeless person. Dr. Nerdly says $30 says if you keep digging, you'll find res ipsa locator. Not because it applies, but because Perry Mason said a lot. Yeah, if they have a res ipsa claim in here, I quit. I quit. Yes, Dick Nutley. That's exactly what you say. All right. Next. All right. Here we go. Let's just read through this brief thread. Ron Mars. So, the Waid lawsuit. This thing started because one guy couldn't accept responsibility for his own failures and shortcomings trying to enter the comics industry. Look at the pro gatekeeping. Who is this dummy? Okay, Ron Mars is a comic writer. I'm guessing he's got a contract with one of the large comic firms. Okay, if anybody can go ahead and tell me who Ron Mars is. I don't know who any of these dummies are. But who's Ron Mars? Someone help me out, please. It's always been about scapegoating an other rather than facing hard truths. This is just more of the same. Yes, some guy who tried to make it into the comics industry and couldn't, kept persevering. How dare he? How dare the peon try to enter the castle? What is wrong with you? Yeah, your old media standard kept him out. Your old media standard kept him out, and he found another way to try and get in. Hashtag Majealousy. Shut up. Gosh, these people are disgusting. Disgusting humans. I mean, I better watch out. They might call my employer. Longtime DC writer. Okay, thanks. Yeah, so someone in the ivory tower is laughing at the guy who wasn't let in through the gate, who then tried to keep coming and eventually made it through the gate. Now it's his fault for making it, I guess. Good job, Meyer. You beat their stupid system that these dying industries are going to have to face the music at some point when all of the people who hate you no longer have to come to your dumb self for a product because they can get it wherever they want. Congratulations. Have fun at Marvel and DC. I'm sure the water's warm. All right. What? He had a deal and Waid made a call and then he didn't. Waid admitted to it. The owner admitted to having been called by Waid. Stop trying to change what actually happened. Magical. Waid stopped a legitimate publishing deal that would have been done if he hadn't interfered. And that, my friends, is the tortious interference claim. In a nutshell. And the defaming of Antos? I suppose that's okay, though. Whataboutism? Tuco-K? And you can say he defamed someone all day. He hasn't been sued for defamation. Sue him, right? Isn't that your logic? Hasn't that been your stupid logic this entire time with Zach? Well, why isn't he suing then? Why isn't he suing? Now he's suing. Well, why is this idiot suing? Hey, morons, you told him since May, why aren't you suing if you have a claim? Now he comes in and does it, and he shoves his giant Indiegogo penis right into your eyeball, and now you're confused as to why? What is wrong with you people? Good Lord. Rhino says Ron Mars is a guy who said the customers for comics are the comic book stores, not the regular people. I mean, technically he's kind of right, because that's all they care about, right? Shipping their books onto someone else who bears the cost of marketing and distribution. Like how auto dealerships are the customers for Toyota, not regular people looking for cars. Right. It's both and, right? Like, without those people, the comic shops close. And then who buys your books with your archaic distribution model and your failure to engage your audience whom you appear to hate? You're worse than Congress saying they don't want the smelly outsiders to come into their state building. What is wrong with you? Oh my God, I just said that. What's wrong with you? What's wrong with you and your disgust for humanity? You're nothing but some dummy who writes stories. There's a trillion of you. There's a trillion of you. And you're not even doing it on your own IPs, are you? Someone else made the moneymaker. And then they left or died. And now all that's left is whatever hack they can get to come in and scribble some words on pages that are guaranteed to sell off other people's work. You giant leeching vagina. Get over yourself. Get over yourself. Who's Antos? Who's Antos? What was the defaming of Antos? I don't even know who Antos is. Someone besmirch his good name for me so I know. Oh, is Antos the person he called a cum dumpster? It's not defamation. Let me just help you. That's not defamation. It's not even close. It's not even close. It's mean words. And it's an opinion about someone. All right. These dudes refuse to see how bad that alone is going to look to a jury. Gacko says, that was effing beautiful. Here's $10 Canadian, roughly 50 cents US dollar. Thanks, buddy. I'll buy the best pack of gum. And Dick Nutley, no, it cannot be defamation if it's true. And I have no idea. I don't care. Never heard of Antos in my life. I forgot to let that one sit back, boys. Oh, that was rough. Okay. Heather Antos, okay. I think you could prove, oh, that's rude. Ryan English, towards a quiet fan to place just off camera. Thanks, buddy. Thanks. Guys, you can see it. Allergic to the stupidity. All right, let's talk about this. His defamation of Antos, who is not a party to this lawsuit, is not alleged to be involved in these claims. And unless Waid specifically discussed Heather Antos with AP, and he didn't, right? Because he wrote down what he talked about what he discussed in Bleeding Cool, while Bleeding Cool was busy auto-filleting him to death. Wait, is that defamatory? Oh my gosh, that was a joke. It was a joke, you idiot. Why would a judge put a statement about a fourth party who's not involved in this action in any way? Why would a judge allow that statement to come in front of a jury? Why? It's overly prejudicial. It's not probative. It would fail the federal rules of evidence, most likely. Maybe a judge would let it in. Maybe you could sneak it in. I doubt it, because it's not relevant to this case. Objection relevance. Objection no probative value. Sustained. Stop talking about this person who isn't here unless you call them as a witness to testify. What are they going to testify about? Probably not the phone call between Waid and AP unless they were on party line, y'all. Akazit says, here's some Hong Kong funny money, Chinese spy. Thank you. Thank you. Always good to take former commie money. Actually, Hong Kong wasn't communist. Always good to take soon-to-be commie money. That's better, right? Hong Kong was independent. Hong Kong was freer than America for a while, y'all. It was pretty interesting. Rocket Ship says, I hope to God this goes to trial. I look forward to Waid spurging out. Man, could you imagine him flopping around on the floor like a dying salmon? Oh my gosh. All right. So in all likelihood, this statement never sees the light of day in a courtroom. One, because it's going to get settled, most likely. If it doesn't, I'm going to be surprised. I'm happy to do so. But if this doesn't get settled, I'll be shocked. Waid is crazy if this doesn't get settled. And so is Zaid. Two. Strong possibility this gets solved on summary judgment and never sees a courtroom. Because I don't know that they're going to really disagree with the facts involved. They're going to disagree with the legal conclusions, but the material facts are likely the same. Zach had a contract. Waid knew or had reason to know about the contract. Waid calls AP. Zach no longer has a contract. What more do you need to know about this? Damages? Damages can be a separate hearing. The elements of the claim, like the amount of damages. Damages are easy to show because he had to create Splato Delgado. Guys, if he had to sit down and scribble on a napkin the logo for Splato Delgado, then he took time and has damages. He otherwise didn't have to do it because he had a publisher. Now he had to make his own publishing house. Or even search for a new one. Even picking up a phone call is damages. even promising to his fans that he was going to deliver, and now not being able to deliver to comic shops is damages. So he's got all the elements. He's got all the elements. It only matters if Mark Waid raises a genuine issue of material fact, and that's the legal standard for not having summary judgment. But what's Mark Waid going to disagree about? Making the phone call? He might disagree that there's an existence of a contract, but he's not going to disagree to the essential facts surrounding the conclusion of the existence of the contract. So he's going to say that Zach and AP made public statements that they had an agreement. That's really all that's necessary. A judge could then, in theory, determine that they didn't have a contract. Sure. But the essential underlying facts about that contract aren't going to change. They're not going to change. This probably won't get past summary judgment because Waid doesn't have a point to disagree on that is a material fact. He only has disagreements on the legal conclusion. There's no way this goes to a jury. None of these dummies are talking about summary judgment. I don't know why. I don't know why any of this. What facts do we need to uncover here, people? What facts? You're only talking about the legal conclusions that need to be uncovered. That's what a jury would be for. Okay. Donut Swan says, is this Super Lawyer live? Nick, I've often said Mark Waid sniffs boys' bicycle seats, but I was only about 80% certain. How many years do you think I'm looking at? All of them. All the years. Whatever years you want. Longneck McGee says, Mark Waid sexually assaulted me 45 years ago at Woodstock. Whoa. Whoa. Big claims. Big claims from Longneck. All right. Next. Okay, someone asked, what is summary judgment? I've just explained it, sort of, but let me succinctly explain it very quick. Summary judgment is a motion that you raise prior to trial. It's a pre-trial motion where Zach has filed his complaint. Mark Waid has filed his answer. Okay, so they've made their pleadings. All right, those are done. If there is sufficient agreement about the facts involved in both of those two pleadings. So this person made this statement on this date. This person made this statement on this date. These tweets occurred. This phone call happened. All of those things are facts. If they agree on the facts, then either party can bring a motion for summary judgment where they say, Judge, we don't need you or a jury to help us figure out what happened. We know the facts of the case. Now please apply the existing law in this way. And then a judge, not a jury, will make legal determination based on the agreed upon facts. That's summary judgment. Now, if the judge says that they disagree on a point of material fact, or that, the other party says, whoa, we don't agree with summary judgment, we have material disagreements about material facts, then the judge will say summary judgment won't work here if they, agree with that conclusion. But that's it. And it's a way to quickly end a court case based on just the legalities when all of the important, read material as legally important facts, are in agreement between the two parties. Because everyone seems to forget this, including these people claiming to be lawyers and law experts, that a judge's job and a jury's job is just to determine what facts are most relevant to this case and which are actual facts. Okay? That's it. They're a fact finder. If you read appellate decisions about judges and juries, they're talking about the fact finder. That's either the judge or the jury is a fact finder. That's their primary role. After the facts are in order, a judge will apply the law that exists. Okay, that's it. That's how the judges work. So, a fact-finding operation would be a trial. A trial is a place to find facts. The other ways to find facts are pleadings and discovery. In pleadings, if everyone agrees on the facts, you don't need to do anything else. You got summary judgment. Get past summary judgment, you go to discovery. Or after discovery or during discovery sometimes, you can go to summary judgment because you find out that you don't disagree. Anyway, That's that, okay? That's summary judgment in a nutshell. In a nutshell. All right, next. We got a couple more minutes, y'all. Probably gonna stop it a little bit after 3 hours. Unless you want me to keep going, because, I guess I could keep going. I'm dying. It's hot, but who cares? All right. Boring. 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 Wait. Not interesting. Oh my gosh. Or you could easily find this. Oh, hey, here we go. Hey, who's this guy? Open a window. I think that's a good call. Let's see. Just a second, guys. Sorry about this. But we need some cold Minnesota air. What? What? Have I never opened this? Oh, there we go. Oh. All right. All right, all right, all right. Ben Cheever says, you missed my first 2 super chats. All were the same amount. Please keep going. This has been amazing. I did? Oh my gosh, I am so sorry. Oh, there's the one that says you missed my last super chat. Same dollar amount. I'm trying to convince myself I don't care about not receiving attention. I only care about not being a part of this masterpiece. Oh, Ben, I'm so sorry. Here it is. Here it is. I found it. Found the other one. Ben Cheever says, God, this is a good stream. Like an hour behind and catching up at 2x. Do this more often. Also, if you remember, read my edited comment on last night's vid. Okay, I will do so. I will do so. Sorry for missing that. Somebody in the window. Yes, that's Antonin Scalia. It is Antonin Scalia. If you're ever on my other streams, my moderator Tess gave me that lovely picture of a judicial hero. Because if you want the snarkiest Supreme Court judge, Antonin Scalia. All right. Here we go. Let's begin at the beginning. Chris Ryle says, Mark Waid, if you need a character witness. Nope. Nope. Why would he need a character witness? What on earth are you talking about? What character what? All right. If you need a character witness, please feel free to call me or the entirety of the legitimate comic book industry. Remember, guys, nobody's legitimate. No true Scotsman. I mean, they're a laundry list of fallacies and jokes, are these people. This is one of the best live streams of all time. Call yourself Beyonce. All right. Can you imagine the judge? This is a judge. I know these people think that they're important because they work for Marvel and DC. I work for Image Comics. Yeah, I got it. I got it. I got it. But can you imagine these people lined up in a courtroom and a judge going, oh dear God. What? I gotta swear all these people in and listen to them. What? What? What are they going to do? Mark Waid's a good guy. He's really good. He's on the side of angels. I said that under oath. I meant it. Thanks, Mark. Go get him. What does a judge care? What does a judge care? Okay, here's how you bring in a character witness, guys. When someone's credibility or propensity for truthfulness or character has been assaulted, this is a federal rule of evidence. When their character has been impugned, you can then bring in someone to bolster their character. Now, you tell me why a judge or jury cares what Chris Ryall or any other number of comic artists say about another comic artist's character. They might want his pastor, I don't know, his wife, someone who actually interacts with this person in a real way and isn't just a fluffer for them on the side. Who cares what Chris Ryall has to say about Mark Waid's character? Somebody does, maybe Mark Waid, not a judge. Not a judge. It would likely be a violation of the federal rules of evidence unless you have something relevant to say about the instant issue. But you don't, do you? You don't. Waid has no wife or kids. I mean, well, that's his deal. That's his deal. All right, next. If that prick wins, referring to Meyer, then we'll literally never hear the end of it. Yeah, at least you know it's coming. At least you know the tide is coming in. I want Meyer to win for no other reason than the cavalcade of clips, the supercut of me saying, "You dummies, I told you so," for hours. Put it a 10-hour Yule log of that and just send it to all of them. No, you don't. I will. I'll tell you I told you so, and the whole world will too, because we're all sick of your stupid commie nonsense and your thought policing and your feelings policing. Get bent. None of us want it. None of us want it. Sell me a comic book, you monkey. That's all we want. Dance, puppet. Dance. Hit your stupid tambourines and make the books. And shut up. No one cares what you have to say outside of that. I have no faith in the U.S. legal system. Oh, I do. Oh, I do. It is perfectly engineered to deliver up some comedy on your dumb selves. All right. Here we go. Here we go. Any dynamo? No. Ladies making comics, don't worry. This is shocking, I know, but the U.S. legal system is incredibly pro-business. Hey, lady. Ladies making comics, hey. What do you think was happening between Zach and AP? It's called business. I don't know if you know what that is. I don't know if you've heard of it. But that's what was going on. The former EIC of one publisher telling another that a virtually unknown freelancer is an a-hole to a judge sounds like, job creators giving each other business advice. Well done. No. Never. Ladies in making comics. The wardrobe of cases, referring to one employer calling another employer about a hiring decision that ends up with tortious interference. That wardrobe is more diverse than Milo Yiannopoulos' BDSM boudoir, lady. What on earth are you thinking? We're talking a robust line of cases. Fully fleshed out law about how really frustrated the courts are with someone interfering with another man's job. They hate it. They literally hate it. Troy Thompson says, Zaid's statement. Note, everything before but is BS. Sammy R.I. says, do you like woks? I love woks. I love woks, Sammy. I stir fry things all the time. All the time. Probably not competently, but good enough for it to taste good at 2 in the morning. Okay. All right. Oh my gosh. Okay, Dan Clark. Voice of reason? There was a contract involved that ended after the phone call by Waid. That hurts business and is against the law. Good job, Dan Clark. An absolutely normal take on it. Thank you. Thank you for having that. Ladies making comics. All I'm going to say as a lawyer, is that look at Rosie the Riveter, Lousy the Lawyer, Lucy the Lawyer. What name do we pick? Is that it looks mighty suspicious that Meyer is not also suing AP for breach of contract. It doesn't look suspicious at all. There's nothing about that is suspicious. That is an unrelated cause of action. It's not mighty suspicious. It's not anything. Note, guys. The other tweets about Meyer, like, oh, he has these 3 options. That was after this conversation. Just bear that in mind. First, it was mighty suspicious. Then later it was like, oh, he had an obvious choice to not do this. That was my point all along. Question, how is this different from Maddox alleging Dick told his fans to call Maddox advertisers, causing him to lose a business partner? I mean, a lot of ways. One, Maddox didn't do that. Or Dick didn't do that. Two, it's telling someone else to do something. If Maddox thinks a person qualifies for tortious interference because of their interference with his contract, good luck. Sue him. Next. He could. He's right. He could sue AP for breach. Let me give you some real I laid it out earlier, right? By screaming about how much it would cost to sue AP for a pointless breach action. But let's do this real quick. 1, it cost prohibitive. Why sue him? 2, AP doesn't have any money. It's a small publishing arm that a guy does part-time after his other job. It's probably set off in an LLC, separated from his other assets. AP probably owns a printing press, and that's about it. What are you going to get out of him? I'm guessing that the money comes into AP LLC and gets paid out to that guy in a great tax-deductible manner. If it doesn't, buddy, give me a call. I'll help you structure it. But there's no purpose in suing AP unless Zach just wanted to scorch the earth. And he doesn't. He stated from the beginning, don't hassle AP. Don't hassle AP. Maybe that's why he's not suing AP. He doesn't want to hassle him for no reason and cost him a bunch of money. Because maybe Zach, maybe he knows what it's like to be on the outside of the industry, to not be the big dog, to not have this sure thing, and to struggle and to work hard to get into it. And he doesn't want to do that to a guy because he knows how it feels to be tossed out of an industry or to be run out of business. Maybe he has some empathy in him. You should try it. Next. Oh yeah, so he could, but if his case is based on Mark Waid threatening AP into breaking the contract, he won't want to attack the blackmailed party. That's true. Have a cooperative witness if you can get him. That's a good point. He asked for a jury, so it plays to the idea of the Mark Waid ogre. And Mark Waid is an ogre in all but stature. Actually, I don't know. Is Mark Waid a big guy? Is he bigger than I am? If he is, I'll challenge him to a fight. Friendly. A friendly fight. With rules. What are we, savages? Oh, he's not a big guy? Well, then I'll let him challenge me to a fight. 5'7". Ooh. All right. Next. Okay. Hot legal takes. Except this is procedurally suspicious. No. No. No, there's no rule of civil procedure stating that he must prove breach by suing the breaching party. In fact, that's not an element of the claim. It's not an element of the procedure. There's nothing about this that is required. I don't know where she's getting this. I mean, we know, right? Reach and pull. Like, if it's as simple as he says, and AP's side of the story corroborates his, they could get a summary judgment. Oh, she knows about summary judgment here. Basically, no one actually has to go to court. And that's literally half the TA case already resolved in his favor. But you don't need to do that. And that would still cost like 15 grand. And it would make one of the people mad. It would put them in an adverse position. More adverse than they already are. Next. He could sue AP for literally $1 to accomplish this. Yeah, great. Why? Why would he make AP hire a lawyer for 10 grand to do it? Unless you're thinking that AP would just agree that they breached the contract. Maybe they would just agree to it. Here's a thought. Think about it. Maybe AP has already agreed to it. Maybe AP has already agreed that they breached the contract. Maybe that's somewhere. I don't know. I hope Zach and his legal team have considered the possibility that they have to prove a contract existed. I hope his lawyer, who's been doing this for 35 years, has considered the possibility that he'll have to prove an element of the claim potentially in court. Oh man, you got him. He didn't even think of it. He should have hired someone who's been practicing for longer, I guess. Ladies Making Comics is less funny than Jamal. Do Zaid's statement. As always, everything before but is irrelevant. We'll get there. I want to get through a couple more of her statements because this is allegedly a lawyer. I have no reason to disbelieve it. No reason. Except I just really think the analysis is lacking. So I don't know what kind of lawyer. I don't know what kind of experience they have. Not selling me on a job application. Not that she's applying to me. Whew. All right. Plus, if he later changes his mind and decides he does want to sue them, he may be blocked from doing so on the grounds that the court doesn't want to repeat the whole bloody thing. Hey, guys, if the court is going to exclude this on issue preclusion, they might require Meyer to add AP as a party. It's called required joinder. They might require them to add them through joinder as a party to the action. But they won't because it's not required. And tortious interference with a contract is different from breach of contract. So this won't have claim preclusion or issue preclusion, most likely. Good job with the corpse temperature take on that one. What are you talking about? All right. AP's also a victim. Again, he could sue them for $1. Yeah, you could sue him for anything. He could sue him for $1 in state court. Why would he do that? That lawsuit wouldn't touch the Waid stuff. It would just officially establish that A, there was a valid contract between AP and Meyer, and B, AP breached it. But they could just show that through all sorts of statements contemporaneous to the breach that are documented all over the internet and in all of these videos and in all of these tweets and in all of these stupid articles. They don't have to. Then the judge in the Waid case would only have to deal with the Waid stuff. Yeah, he only has to deal with the Waid stuff now. So even though AP publicly announced all this stuff, it says they agreed on terms. Yeah, that's called making a contract. What? That doesn't necessarily create a contract. Agreement to terms is literally how you create a contract. What? You took contract law. It's a required 1L course. Of course, agreeing to terms means they had a contract. She's a contract negotiator for Raytheon? Raytheon! What are you doing with this person? Bagel Goose says, I'm absolutely loving this stream. Thank you for making my day. Yeah, AP tweeted it's official. Thank you, Bagel Goose. AP did tweet, it's official. We're publishing. All the evidence points to there being a valid and enforceable contract under Texas law. Only all of the evidence. Only all of it. You don't need a document. A document is not a contract. We call it that. That's colloquial. A document is a memorialization of a pre-existing agreement. Period. Period, period, period. If you don't know that and you're negotiating for Raytheon, go back to CLE or go back to school. Do something. Get help. Get help. But you're probably negotiating under Uniform Commercial Code, which is different sets of enforceability. This isn't a UCC claim, Puddin'. This is a breach of contract under common law. You need the common law elements of contract, not the UCC elements of business dealings. This is common law, not Uniform Commercial Code. Stop conflating them if that's what you're doing. You're doing it wrong. Sammy Ree says, do you think that when Meyer was still a kid reading G.I. Joe, he ever imagined being the hottest topic in the entire comics industry? No. No way. No way would he have imagined this. I don't think. Not in this way, certainly. Okay. Why not use a shortcut? Guys, listen to how dumb this is. Listen to how dumb this is. Why not use a shortcut that costs $10,000 to $50,000 that could take upwards of a year if they fight it? That's your shortcut. Or your non-shortcut, which is the costs are already incorporated into your pre-existing lawsuit and it takes no extra time because you have documentation of everything. Which one do you pick? Ladies making comics, take a step back from your righteous, indignant defense of Waid and think about it. Which one do you pick? And if you're advising clients to do what you're advising here, don't do that anymore. Don't interfere with ladies' employment contract with Raytheon. I'm just asking what Raytheon's doing. I'm not suggesting they fire her. I don't care about their employment with her. Dear Lord, I would never hire this person based on this to do contract work. Maybe they're great at other things, certainly. Oh my goodness. Agreeing to terms in the law is a contract. Not always. Okay, when not, Puddin'? Was there valid consideration? Yes. Obviously. Consideration is the exchange of promises required to make a contract. I talked about this earlier. Basically, did Zach promise to make a book? Did AP promise to print and distribute the book? Neither of those two parties needed to do those things. So if he promised to do that and then they promised to do that, consideration met. It doesn't matter if the consideration was free. The court will give value to what the parties deem valuable. Obviously, there was consideration. Something of value exchanged for the promise of performance. That something of value could be another promise of performance. If Meyer never delivered the book, would AB consider him in breach? Yes! Yes! Absolutely, they would consider him in breach. What are you... Who first reached out to who? Doesn't matter, sweetie. What are you talking about? What are you talking about? How many times did they go back and forth? One is enough. One back is enough. Or 1/4 is enough. There obviously has to be a back and a forth, right? Because you have to say, I want this, and the other party has to at least say, okay, one of those. How many times they go back and forth? How much was he actually relying on them? His reliance doesn't matter unless it's promissory estoppel. I see what you're doing. That's a dumb tack. It's not promissory estoppel. They've exchanged promises. Now you perform or you pay. Contracts 101. You've got an agreement. Perform or pay. Dummy. And I'm telling you all these factors are still relevant under Texas law. Now look, someone comes in with a reasonable question. You're overlooking that suing AP, a Texas-based publisher, in the same action would mess with diversity jurisdiction. They would have to take it out of federal court and put it into state court if AP was a party to this action. Myra wants this in federal court. Can't include AP. Look at that. Solid legal statement. Good job. Are you saying Waid's fans aren't legitimate lawyers, internet lawyers? I wasn't saying that, but yes. So then he says, then she gets into an argument. Funny, I bring up a procedural issue that actually has tons of bearing on the case, but none of you believe me. Rekieta brings up one that has a simple solution, file a separate action in state court, and he totally gotcha'd me. No, why would you do this? Practically, file in state court is silly. All right, next, not intended to gotcha at all. Just not sure why you were so insistent that he sue AP. I see you're a lawyer and I'm curious, other than clearing the legal hurdle of showing breach, why you want this when it's not required under Texas or federal law as far as I can tell. I'm willing to be corrected and for her to say, no, procedurally it is required. I was willing for that. Obviously not forthcoming. Parody bit. UCC has a set of rules for how commercial contracts are dealt with. Commercial sales, right? If they're not bringing claims under UCC, they're under common law. Common law is the body of established law going back to 14th century, 15th century English law and building from there. Okay? We have common law understanding of how contracts are formed. And then we have Uniform Commercial Code understanding of how contracts are formed. They're different things. They're sometimes interrelated. They're not always required to be together. Zach is not bringing a UCC claim here. He's bringing a common law interference, breach of contract claim. So there's that. Okay. Hopefully that helps. I'm getting past it. All right. It wasn't a gotcha. Yeah. I'm not really insistent about it. I mean, you've only been tweeting stating that it's procedurally suspicious and that he definitely should do this because it'd be so simple. But it's just something I considered thinking about all the steps that would have led to him filing this complaint. Would you at least agree that it's something that his lawyer should have / probably did suggest? Sure, of course. Of course his lawyer hopefully had a very thorough talk with him beforehand. Yeah, parody bit, doing a video on the UCC is the fastest track for me to getting arrested for causing the suicides of a bunch of people. All right. And now it's on to Discovery where anything can happen. It's not actually on to Discovery yet, guys. Waid hasn't even filed a response yet. So it's not on to Discovery. Anyway, hey, there's the advertisement for this thing. All right. Okay, my voice is going. I'm getting really tired. I have to go to the bathroom. So, can you take the bar in Minnesota without a JD degree? I don't think so. Okay, next. Did you save the tweet of the idiot who found the DNC YouTube vid saying that 6 comics pros should be fired? No, I didn't. I'm sorry. Before I go, I want to go through Mark Zaid's statement. I think it's in Bleeding Cool, right? All right, here we go. I'll be out of here in a minute. We're going to cover this Mark Zaid statement. Let's see. Oh, what a disaster. Oh my God. How many articles do they write a day? We're just going to do this. We're just going to do this. No, not the most relevant. Newest. Here we go. Do you think it's possible that Disney and Marvel is paying for Zaid? Sure. Yeah, it's possible. I can't say that it's happening with any confidence. No information to believe that to be true. But in theory, sure. They could do that if they wanted to. All right. Let's see. Is this the statement that you're talking about? Okay. All right. Mark Waid's lawyer has responded to inquiries made by Bleeding Cool earlier today. We'll see if Mark Waid's lawyer responds to my inquiries because I intend to invite him on this show. I don't think he's going to come on. Just a guess. But I would love to have him. And again, Mr. Zaid, if you happen to see this, I will treat you with the utmost dignity and respect and allow you to certainly lay out your career, your stunning achievements. You have your own Wikipedia page, which I'm told is very important if you're a lawyer. And that's not directed at you. That's that was told to me today. And you have done some high profile cases, and your passion is comic books. Law and comics is where my channel's at right now. It'd be a great fit for you, and maybe you could find some sympathy and some common understanding of your passion with people who've been watching my show. So I will formally invite you properly by lawyer email. But here we go. Okay. Mark will aggressively fight this frivolous lawsuit with every legal means available. Good. But at the end of the day, what will have the greatest favorable impact for him are the actual facts. Okay. Yeah, I guess. Mr. Meyer's lawsuit will further reveal to the world his true nature. Are you treating this like a comic book, Zaid? Like, do you think you're going to pull the mask off and find Destro running a secret Cobra Law operation? Okay, sorry. Ironically, his own litigation will likely increase the professional isolation he alleges Mark has caused. I don't think he's going to increase the professional isolation in any way. because it's at maximum. That's the whole suit. It's at maximum, Zaid. He's been thrown out. Thrown out. Do you think he cares about industry recognition at this point? He's making a new industry. All right, guys. All right, guys. This has been great. This has been great. And I hate to turn in on such a wonderful crowd who's been very generous to me and very gracious to watch this and participate. It is time for me to go relax with a little bit of ice cream, a little bit of Warhammer novels, and chill out, wake up in the morning, and go do some attorney work. Thank you all for watching. We've got fun stuff coming this week. Announcement. If you guys are following this stuff, which I know you are, and I know some of you, this might be your first time on my channel or whatever, I'm trying to confirm a debate between Ethan Van Sciver and a guy named Jason Youngblood. Some of you may know him. He's the guy who puts the Dramagate tweets out. I'm working on that. I'm hoping to accomplish that this week. But I want to do that within the bounds of these two gentlemen's very busy schedules. And of course, with mine, that will be hopefully on this channel. I am hoping to have that Friday, but I have to confirm this with these gentlemen. So stay tuned for that. Stay tuned for that. I think that'll be interesting debate. The last debate with Ethan and Thomas Roylup did not go as planned. Lots of people were very critical of Thomas's performance. I thought Ethan brought a very good show. My interview with Thomas was a different story. I thought he was better prepared and presented in that interview than he was at the debate. But you guys can check him out and see if you agree or disagree. That's fine. But Jason Youngblood has asked me to set up a debate. I don't want to say that Ethan has fully agreed at this point. We haven't set up any of these terms, and I will hopefully narrow down the topic of debate so we have some focused discussion. But Jason is very critical of some of Comicsgate's features and fans and all of that stuff. So it could be a fun time. Stay tuned. Stay tuned. Other than that, we'll probably be doing Russell Greer's book later this week if you're following Russell Greer. Talk about commies killing Linux. We might do that. And then we may be doing an expose on Kevin Landau walking away from yet another lawsuit. If you're following Russell Greer, let me let you know something. I am trying desperately to cover Russell Greer's criminal complaint, working on it. And I'm working on an interview with someone who will blow your mind. Blow your mind. So, Lost Cause 78. I'm working on them. I'm working on them right now. Yeah. Did you message me? I think you messaged me. If it's Taylor Swift, guys, I would tell you, there would be bullhorns into the microphone if it was Taylor Swift. No, it will not be Taylor Swift yet. We'll work on it. I don't know if she'll come on the show. Maybe if I make her a song. But if it's not Taylor Swift, Who's the next best character in Swift v. Greer in Utah? If you are following the Russell Greer thing, not Greer. Greer would never come on this show. No, no, no. Greg Scortis, baby. Yeah, Lost Cause 78. Yes. No, Greg Scortis. I'm working on Greg Scortis, so stay tuned. If you like it, Greg Scortis is the guy who represented Taylor Swift and Ariana Grande against Russell Greer. So, that's the thing. Zaid, I am going to ask formally for Zaid to come on. I suspect he will not want to talk during litigation. I suspect. But anyway. So, thank you guys. If you're not subscribed to my channel, please do. We're on the push for 10K subscribers this month. That would put me at 10,000 subscribers before a year of doing this, just by a hair. And I really appreciate the help if you enjoy this stuff. And the more subscribers, the more viewers. That means more topics, more live streams, more videos. I love it. So you guys keep supporting me. Even with just clicks and views, I will never demand people pay me anything. I will humbly appreciate it. But if you keep supporting me with just subscriptions, views, and spreading the word, I will create more and more content on all sorts of subjects. Anyway, guys, I gotta go. I'm like getting to that, like the I love you drunk part, and I'm not going to do that to you. Thank you for watching. You guys have a great night.